people and staff to process the extension of approval, which is statutory by the AICT. They have stopped that. The urgencies they have fixed to 20th of the last. So can I pray tomorrow?
Give your slip. We will
And not
Oh,
your,
please.
your lordship, both my lord. I'm a L1 tender, my lord. That is L2. Entire proceeding has been stayed. Medical equipment they have to supply, my lord. Entire hospitality has been stopped. Your lordship be taken up urgent, my
Who
lord.
has stayed?
That is L2, my lord. Stay order has been granted by this honorable court. L1, I am the L1.
Have you filed any application
Yes,
for
my lord.
vacating?
Intervention petition already filed, my lord.
Application for vacating, you have
Vacating
filed.
the stay order already.
All right, that orders will be.
Your lordship.
I
Please
may-
oblige, my lord.
I may be permitted to take your lordship's leave. But the matter was before my lords in sometimes in April, my lord. It has been delisted. Urgent.
Give your slip.
I may be pardoned, my lord.
Your lordship, one
Okay,
PI
DC
matter,
matter.
illegal encroachment of the land, government land, your lordship, which is reserved for the Mahila Samiti and self-help group, your lordship.
All right, give your slip.
I may be pardoned, my lord. My lord, I had a matter yesterday. My lord, I had a matter in item 22 yesterday's list, and the matter was likely to be taken up by after launch, immediate. My lord, but unfortunately, my lord's honorable court bench did not function yesterday. So I pray, my lord, I can take up
We will try.
WA number 511 of 2024. my lord.
All right. Yes. All the best.
Matters under the heading for orders, item number 27. May I please, my lords? My lords, in this writ appeal, my lord, there has been a delay of 297 days. I have filed one IA. My learned friend appearing for the respondent was supposed to give one reply.
Lordship, in the subatem I am appearing. I have prepared the objection, your lordship. If your lordship will permit me, I'll file it in the course of the day, your lordship.
What is it? We are condoning the delay. Delay we are condoning and we'll
As
hear
well.
you on merits.
As lordship, please.
IA 1519 of 2024, condonation of delay. There is a delay of 298 days in filing the writ appeal, full stop. Although time had been granted to the respondent for filing an objection, the same has not been filed. But Mr. S.K. Mishra
Myself, SK Mr.
has not been filed.
Second
Third-
case, I'm
Heard Mr. You're there in the first case.
first case, I'm
Heard Mr.
Miss.
Mr. Bimbisar Das, learned additional government advocate, and Mr. S.K. Mishra, learned additional learned counsel appearing on behalf of the respondent. Considering the grounds taken in the IA for condonation of delay and in the interest of justice, we feel that this is a fit case for condoning the delay in filing the writ appeal. The delay is condoned, the delay is accordingly condoned. The IA is allowed and disposed of. Yes. Second one, what is the delay?
That is, my lord, 330. There has been delay of 336 days.
Same order.
Same. Yes.
Common order. Yes.
Yes.
Yes, sir. There's a delay of 338 days. Yes. Same
Well.
order. Only counsel will be Mr. S. Shekhar. sir.
Right.
Yes. A common order has been challenged in the present writ appeal 465 of 2024 and in 468 of 2024, where we have already condoned the delay. Then that same order. Order. The order which was passed in 468, same order in this.
It's
Counsel will be Mr. S. Shekhar.
It's not a common order. In my case, there is a separate writ petition. In his case, there is separate. My writ,
So I had filed the writ petition that is WBC number 5568
Mr.
of
Counsel, the order is one or the orders are different?
different.
orders. Then that.
Just a minute, let me check. I may be mistaken, but I think I found the same order.
So why they have been listed together?
Yes, please check page 17.
Principle is the same, madam.
WPC 20713 of 2016. Rasmi Ranjan Das, oh, that is not listed here.
But in my case, Miller, page 17 is my order.
Just
But
a
then-
minute, just a minute. Rasmi Ranjan Das and others versus State of Orissa. And one is Kishore Chandra Majhi versus State of Orissa. So there, Chandra Majhi, there's a common order. No, he's right.
Right.
He's right. This petitioners are different.
Yes.
Yes,
Page-
don't write that. You're right.
Ma'am.
Because that was Rashmi Ranjan Das.
Ma'am.
You're right. For portion, please don't write that. Thank you for pointing out.
Item 28.
You received copies of the writ appeal?
I have already received it.
You received a copy of the writ appeal?
No, Your Honor.
Copy of the writ appeal may be served on learned counsel for the respondent by tomorrow or by Monday?
By Monday.
Monday, if not already served.
Yes, madam.
List the case on 20/11/2024 for fresh admission.
Item 28.
20 minutes will be permitted to withdraw the writ.
All right. Please write down the prayer. Then Mr. Pratik Das, learned counsel appearing for the appellant, submits that the appellant doesn't want to proceed with the writ appeal and may be permitted to withdraw the same. Are you filing a memo?
Yes, I'm
All
fine.
right, and he files a memo to that effect. Considering the submission, the writ appeal is dismissed as withdrawn.
I have appealed for approval.
Mr. Manoj Kumar Kuntia, learned counsel, has appeared on behalf of the respondent number
5.
5.
Item 29. 29, my lord.
They are not sought for.
Yes, sir has not been page marked in item 29. Why do they do that? I don't know. Yes, sir.
Yes, ma'am.
It is not there in the index.
In course of the day.
Copy has not been served because you appeared without notice being issued. That is,
Because my lord, I no notice, because of the my lord.
that is why, since you have appeared, unless we direct, how can they serve a copy?
That's right.
Yes. Since Mr. Lakshmikanta Mahanti, learned counsel, has appeared on behalf of the respondent, copy of the IA for condonation of delay may be served on him.
Well.
May be served on him. Today you have a copy?
By tomorrow.
Copy must be there. It has not been, notice has not been issued.
In course of the day, your lordship may say.
Copy may be served on him in the course of the day. First of all, that IA for dispensing with filing of certified copy. Have you received the copy? Have you
Certified copy
received
we
the
have not
certified copy?
received. Certified copy we have not received, but I am expecting, because in all the cases, within 2-3 days, it will be
All right,
steps we have
all right.
taken.
Mr. Bimbisar Das, learned additional government advocate, undertakes to file the certified copy of the impugned order within within 1 week by 20/11/2024. He also undertakes to serve a copy of the, instead of course of the day, make it by 20th. Undertakes to serve a copy of the IA on Mr. Lakshmikant Mahanti, learned counsel, who has appeared on behalf of the respondent. List the case on 20/11/2024.
Another similar matter and even not listed till that. Similar matter, I'm looking at this case.
Similar means,
The same issue.
what is the number?
And WA number 66324.
WA double, there has notice been issued?
Then the notice issued on the limitation.
WA 663.
My lord.
Mr. Mahanti, learned counsel, appearing on behalf of the respondent, submits that similar issue is involved in WA 663 of 2024, where he has appeared, where he has appeared on behalf of the respondent.
That was on
After-
July was not listed.
Okay. List WA 663 of 2024 along with the present appeal on the next date.
Orders matter over.
Just the allotment has not been.
Item number 1.
In this case,
I have just now filed the counter affidavit by DMT. And I have not filed in the registry because today morning it was all ready. So if my lord wants, I can put.
can you also take it up on 18th? Though counseling starts from 18th or till 27th, but so take it up on 18th. Yes, sorry, yes, on 18th.
My lord, 19, 18, I will not. 19, it will be taken on 19.
19.
No problem.
Lords, in both these matters,
My lord, we have filed.
have filed interim applications for intervention, my lords.
Let them be hard. Yeah. At the time of hearing, let them be hard. Yeah.
Can copies be served, my lords? Can copies of the writ petition and the counter filed by the DME be served?
You don't have a right as on date unless you're.
I agree, my lord.
You can get.
But since your lordship is fixing it for hearing,
Since intervention application has been filed, just exchange the pleadings.
My lord, we have also filed on intervention petition.
Go ahead.
I have also.
How many intervention means you are opposing?
Yes, my lord. We are in service candidate, my lord. We are in service candidate, my lord.
Then
See, if my lord allows extension, my lord,
I can't-
they will fall under
Just-
clause G2. Then we lost our rank, my lord.
We have completed 3 years
Yes.
service in
you
service.
Yes.
understood. Last date
We have worked, my lord, in vulnerable area designed by the government, my lord. We'll file it, my lord, counter kindly this submitted.
Try counter.
Our applications may be allowed.
Not right, you have to
Mr.
file counter.
Monk and counsel representing
Also fix it on 18th.
DMAT.
19.
DMET has states that a counter affidavit is going to be filed today, copy of which has been served
Already, sir.
upon learned counsel for the petitioner. Stop. It has been stated at the bar that some intervention applications have been filed.
My lord. Number 15061.
Stop. Intervention applications have been filed. Next, this matter on 19th. So as to enable within first 5 cases, as the first case, so as to enable learned counsel for the petitioner to consider the counter affidavit,
Yes.
which is going to be filed on behalf of the DMET. So stop. It is expected. We have served copy of the intervention
Yes, my lord.
application.
Yes, we'll stop the DMT, my lord. We'll solve right now.
I have served copies on both sides.
I'll solve to my senior. I'll solve my senior, my lord. I've solved DMT.
Let the pleadings be exchanged. So stop. Let the registry ensure that interlocutory applications filed for and the counter affidavit intervention applications filed for the intervention applications and the counter affidavit be placed on record
My lord.
on the next day.
Grateful, my lord. Obliged.
This matter on 19th.
Lords, our IS are on record. IS filed by me, 15173 and 15174. They are already on record in the list.
Both the cases we will take up together.
Yes, ma'am. Yes, ma'am. Both the same. I will adopt this counter in that case.
15074
Same counter.
15.
just give a memo to that effect. When you're filing the counter, you can give a memo to that effect
I
that
have
also come on
already given a
record.
memo. Memo is ready, I have filed it.
Regarding cut optics.
Yes, madam.
that will
Yes,
be
madam.
record.
Yes, madam. That I have done.
What do you want to say?
What is-
15074 of 24 Miller. Interval petition. Miller.
Intervention, all the.
Miller. I need permission. Your lordship had allowed my application for amendment on that day. Somehow that application for imprisoner party, somehow it has been left out. Appears from the list. That,
For the
imprisoner party.
implement has not been incorporated.
Yes. Yes. The consolidated I already filed. I have incorporated also the persons who are sought to be implemented as party. Under the impression as if your lordship allowed that application, but that is IN number 14704 of 2024. That's flag B. Convener, PG Medical Council. Counter, I think.
IE number 1417
04. 70.
14704 of 2024. Stop. This application has been filed seeking impleadment of impleadment. Who are to be impleaded?
The director,
Seeking amendment in the retribution by way of
3, 4 and 5.
impleadment of the persons mentioned in
Director of Health and Family Welfare.
mentioned in the schedule
Convener, PG Medical
for
Council.
their impleadment,
And National Board of Examination in Medical.
for their impleadment. Stop. In the facts and circumstances and considering the nature of the relief sought in the present application. In these applications, the same is allowed. Stop. The counsel for the petitioner shall be at liberty to file consolidated writ petition if not already filed.
That one. Just submission item number 2.
There is direction for payment cost under the so a copy on respondent. We have already served copy on respondent 21/10/2024 and cost has been paid. This is fine.
Yes. So now we can hear it on merits. Cost you have paid.
It will come next week.
In this case, I am appearing along with Ms. Patnaik for respondent. If my learned friend.
So again, the system has changed. Generally, the petitioner or the appellant, they have to be
Yes.
on this side. It will come next week.
As requested on behalf of the appellant, list this matter on next week.
Well,
Item number 3.
regarding rehabilitation, whether 19 and 20 rule will apply or previous rule will apply, that is it. Your Lordship previously given direction, file some copies of judgment.
Yes, we can decide it. We should decide.
Here I have entered appearance for this private petition. Here I am covered by the judgment of Molananda City. Because Molananda City case, so this honorable court had directed that rule 2020 will apply.
Mr. Samantra, you must have been hearing when you were on the side, Malayanand Seti, peculiar facts and circumstances of the case.
Maybe, but the honorable court has said that because, of course, Supreme Court has kept the, open the point. But thing is that honorable Supreme Court said that because you have kept it pending for so long, without any fault of that particular beneficiaries, so it should be applied, And so far as the Bindu Sagar case is concerned, that is on a different aspect, because they are point were different. And admittedly, my application was since 2017. They kept it pending till 2023. For
So
6 years.
shall we hear it finally?
Yes, that I'm saying.
This is what we also
Identical
suggest.
matters day before yesterday, your lordship, AG was addressing that he said that he was submitting before the Honorable Supreme Court and your lordship kept those matters after 2 weeks.
No, maybe, but now since the matter has been taken up, we can see what is the issue involved.
So let him place
In
his case.
so
and
many-
we'll hear you.
Yes, we also fixed it.
In so many
No, no,
cases,
fix a date. If he's ready
similar
to argue,
issue,
we'll
Malayanand,
fix it today.
Hindu Sagar, we will see what are those, what is the law and what principle. There must be some clarity. Yes, you please begin.
If you are ready.
Here, in the rehabilitation matter, your Lordship was directed to file covered copy, judgment and all that.
No, if you are ready in this case, forget about yesterday. If you are ready in this case,
Do you have copies of the judgments?
Let it come next week, my lord.
See, speaking for myself, these two decisions, Malayalam City, Bindusagar, and then
Malayalam City.
rehabilitation scheme,
Your Lordship, disclosure one.
I need to address those issues.
Yes, sir.
Otherwise, I do not find there is any clarity. Is there any clarity? Oh,
No.
then
Clarity in the sense that Bindusagar, the rule has been quashed. They said that it will apply prospectively, not retrospectively. So all those applications which were pending before the authorities, prior to, on the basis of 1990 rules, automatically, even on the basis of Bindusagar, it will apply 1990 rules, not 2020. And Malayananda City case, Honorable Supreme Court, even though it kept it open, state has not gone in any other clarification or any other case.
so we shall reconcile the two decisions, Bindusagar and Malayalam City.
When? Tomorrow?
Let him dispose of the light of that day.
Huh?
Hearing now.
Light of what?
It will come next week.
As requested on behalf of the appellant, list this matter on next week.
Two matters.
Item 4.
The Lordship has fixed to.
Okay.
Item 4 on behalf of Mr. Das can pass over.
Oh, Malayalam City or Bindusagar, the judgment take it. And those two rules. You will also.
Mr. Das, the other cases, what are the numbers? Do you remember? If you have the list, it was there yesterday. Because why piecemeal? You can address all four and we can dispose of.
I'll give to your Lordship. Your Lordship, grant me some time, I'll go.
No, when was it?
Day before yesterday, AG was addressing your Lordship. He submitted that in the Honorable Supreme Court, such matters, series of matters were heard. And since no order has been passed thereon, that is why your Lordship kept this matter 2 weeks after. Item 4.
Item 4, Madam, on behalf of Mr. Das kindly pass over. Please on.
1 week as requested.
Item 5.
Next week, my lord, here Mr. Rathway is appearing, senior advocate appearing for the appellant. It's some personal difficulty.
On the ground of personal difficulty of and senior counsel, Mr. Rath.
Couple of months.
Let's this matter on 1 week. Yes.
Item number 6.
Lord, I'm appellant. I have filed Vinama today. I prefer tomorrow only.
You have filed what?
Ukulana for the appellant after taking consent from the earlier counsel. I have filed today. I prefer
So
to.
when was the writ appeal filed?
But at the order of the Honorable Single Judge, that the Honorable Single Judge has dismissed the CMP, where the issue was under Order 11 Rule 14 in the suit and the defendant. There, my lord, plaintiff has filed the suit.
No, when was the writ appeal filed? They are saying so many
Lord.
things.
For the respondent, appellant is not there.
You are for the respondent.
No, my lord, I am for the appellant.
Oh, you filed wakalatnama for the
Yes.
appellant?
Yes.
All right. Is this writ appeal maintainable?
It is the order of the Honorable Single Judge. I have
Single
filed
judge in an application under
226 of the.
challenging what order?
In the order of the passed by the civil judge.
So will
the
that
two-
be under 226 or 227?
No. In the
The-
suit, there is a order
We are
passed by
not,
the.
we understand. No, there is nothing. Tomorrow, as requested on behalf of
You come ready tomorrow.
Man,
appellant, let's this matter.
Your name, please?
S.C. Mohabbat.
SC Mahapatra.
AC Mahapatra.
Sorry,
Ajit Mahapatra.
A.
Item 7.
My lord, I have challenged the order passed by the Honorable Single Judge in WPC number 5496 of 2024, dated 14/8/2024, by the annexure 17 to the appeal memo, my lord. Your lordship can have it at page. It starts from 412 to 422.
Yeah.
Your lordship will kindly see the institution in question is a totally private, recognized, unaided educational institution. Is governed by a separate set of rules prescribed under the Orissa Education Act. The Honorable Single Judge, while deciding the matter, take assistance of the rules prescribed for the aided educational institution and decided the matter. Those rules had no application so far the petition appellant's college is concerned. And your lordship will kindly have a look to rely on. I would draw my lord's attention to the relevant paragraphs of the judgment, which starts from page 419.
Permitted your lordship, there are 3 writ appeals actually before your lordship in that serial. The 3. In the chronology, if your lordship will see, the first writ appeal is that of the state. If that is allowed, these 2 writ appeals may become infructuous. So just because then I think that reduces the burden of the court.
So you are for whom?
I am also have filed a writ appeal challenging the same order which Mr. Ratha is placing, but on a very different ground. The initial.
But who is for the other side?
Mr. Ratha is on the other side as well as the state. And in Mr. Ratha's writ, I think.
No, you are the appellant.
I'm also the appellant.
All 3
He is
are
also the
appellant.
appellant.
Yes, but the state's writ.
So notices have been issued or not?
No. But the state's writ is the first in the chronology, which
Alright.
challenges a prior order. And if that is allowed, these 2 writs will become infructuous.
All right, we are issuing notices then.
If you're willing to accept notice, we can hear all 3.
Elections are we are willing to.
No other parties, I hope.
No. Even state's writ, no notices have gone.
There is a limitation so far state notice is concerned. There is a 169 or 70 days limitation. And that is for a different writ application, and we are in a different writ application, my lord.
No. The writ appeal which has been filed by the estate, who are the parties?
My lord,
Whether that is listed or not? That is not listed.
That
That is
is there.
listed.
In fact, that is the one that was listed first, and then these 2 were
All
called.
right. So what is the number?
1943.
1943 up to 124.
there she is not a party, I am the party. 1943 of 2024.
He is not a party in any of the cases.
No, I'm 1943
Appearing
state's appeal.
parties.
Miss Ratha is not a party.
Have you can you implead her party?
That's a different writ application, my lords. That writ appeal has no bearing to present writ appeal is concerned.
What wrongs he has committed?
In person.
But the governing body is a respondent.
Yes,
All right. So in 1943, who are the parties?
Governing.
My lord,
Governing
governing body is also a party.
Only
Where I am
governing
the- where I am to appear for them.
You are appearing. And
Yes,
who
I am the
else is-
governing body.
Who else?
No, there is sole respondent.
Only one respondent.
Only.
So in the state's appeal, you are representing governing body.
Yes, my lord.
No notice is required to be issued because you accept.
Yes, but see, your lordship will condone the delay, then no notice is required.
Even otherwise, even for condonation or delay, notice is required. So 169 days is nothing for
133 days.
133 days. For the state of Odisha,
And there's a substantial cause there. I mean, I know your lordship's viewpoint that delay does not defeat if there's a substantial.
where is that? Have we delivered any judgment on this?
I have to find out, but I have been repeatedly observing your lordships you in these cases, so that's why I.
Mr. Samantha.
Limitation पे judgment है. One issue can mean order dealing with the case law.
Yes, that's also been the Supreme Court's view, that delay per se will not be.
1943/2024 में IA number so and so. This application has been filed for condonation of delay of 133 days in preferring the present intra-court appeal by the state of Orissa. The Mr. Rath, and senior counsel.
Mr. Mahapatra will appear along with you.
Yes, ma'am.
Mr. Mahapatra and counsel accepts notice on behalf of the respondent. Stop. Have you received a copy?
About the writ appeal state file, we have not received.
In course of,
At least do it.
in course of the day, I'm giving. Okay. In course of the day, I'm giving.
Let copies of the of this application as well as the memo of appeal be served upon Mr. Mahapatra in course of the day. So, list this matter tomorrow. On these matters tomorrow. For tomorrow under the same heading. Tomorrow I'll do that.
Item number 8.
May I request to make the state case the lead case, your lordships?
That is that can be we can do at the time of hearing.
Yes, your lordship, because
But in the meanwhile, please find out, because if I my memory is not so weak, then I have rendered a recent a judgment. We have rather
we'll check.
on the point of condonation of delay.
We'll check.
Yeah.
Probably in the teachers matter, which I think where there was an insistence that
Law
the
invokes
point
the
of
same.
delay, probably the teachers matter where your lordship said that if it's I will find out.
You asked the council who were usually sitting here, the state council, probably they might remember.
I think that was a different set, but I remember that your lordships in that teachers matter where the petition there was a insistence to dismiss the matter on limitation ground because others were, and your lordship said that no, if there's a substantial right involved, I should not.
All matters we have been saying that, but
Yes, that matter
is an order.
we'll find.
There's a reasoned order dealing with the Supreme Court's decisions also.
No.
Item number 8.
Item 8, my lord, your lordship may say order number 2. 7/10/2024. Your lordship had framed an issue. Order number 2, serial number 3, my lord. The state of Odisha has been implemented for the sole purpose of this court to consider as to whether SEBC is a part of OBC or not. So they are to answer. State is to answer this one.
May I submit, my lord? The facts of the case is like that. Earlier, I am for the present writ application, the present writ appeal. I am for the OP number 3. What happened in this case? The BPCL, I was just selected as a candidate. Then another complaint, another candidate who is unsuccessful, that is Biswajit Maharana. Earlier, he has filed a complaint against me before the BPCL. that the SCBC is not equal to OBC, so his selection may be rejected. And the BPCL has already allowed in my favor and rejected the claim of unsuccessful, that is Biswajit Maharana. Challenging the said order, Biswajit Maharana filed an earlier writ application before this honorable court, that is writ application number 18528 of 2019. In that case, BPCL has filed counter in my favor. My lord, have a glance, though my learned friend has not filed, not annexed such counter. May I place, my lord? The counter filed by the BPCL in the earlier writ application, rejecting the claim of the unsuccessful candidate, and in my favor, he has declared that in that writ application in counter that SCBC is equal to OBC as per the central government press note. My lord, have a glance to the earlier writ application of
SCBC is OBC.
my lord.
This was the stand.
This was his stand, and in my favor, order has been passed by the BPCL. And in that writ application,
You are SCBC.
my lord,
You are SCBC.
my lord, I am SCBC. I am SCBC. My lord, have a glance to the counter they have filed in the earlier writ application. That is paragraph 8.
That is there in the order itself, my lord. Page 60, that order is there. What my lord?
Maybe, but
Your
your
submission
counter,
is that SCBC is not part of OBC.
Yes,
yes.
my lord. Yes, my lord.
You are the appellant.
Yes, my lord.
State.
How do you
he
substantiate?
submits the BPCL. My learned friend has in the writ application in their counter submit that SCBC is equal to OBC.
No. One thing is, if that is not the law, just because they are stating that won't be the, we are not supposed to accept it. We have to examine whether the submission was correct or not.
Yes, my lord.
So that is just merely stating it won't do.
Nay, relying on the press note.
Press
Relying
note
on the press note in that,
also is
in
not
that
law, my lord.
counter, my lord has gone to the annexure B2.
Okay. Where is the press note?
My lord, see in that counter, they have
Yes.
annexure B2, my lord. In counter, annexure B2, Press Information Bureau, Government of India, Ministry of Social Justice and Empowerment, under the caste under OBC category, that is publication on 11 August 2015. In the BPCL counter itself, annexure B2, my lord, the first central list of OBC was notified in 93. My lord, have a glance in the serial number 21, my lord, Odisha. Serial number 21, Odisha. Provision for a reservation of 27% of socially and educationally backward classes in the post and service in the state. They have relying that notification,
They have.
passed order in my favor.
Subsequently, if there is any other notification or any change, that we have to see.
My lord. My lord.
Let's see.
Some document.
Every class.
Mr. Das, who is there? The state government had been asked to take instruction.
And furthermore, annexure 5, my lord, learned single judge as relying their submissions, passed order, disposed of the case, and I directed him to issue LOI in my favor. That is annexure 5, my lord, writ appeal, annexure 5, running page 60, my lord. As per their argument before the learned, my lord, the weight, yes.
So just you want status or not, because you were disputing. They don't have any doubt over it. Because he has instructed on the last date. That is for that for the motion.
We had said that. You said, read them as appellant B, but on-
Yes, what is your submission?
Lordship, mere press notification is not law. That I would submit in that
Then
like.
what is the law?
I pray next week.
No, sorry.
Just, it's not like, I'll just cite a decision.
No,
my
no,
lord.
sir.
Let it
Unnecessary,
come tomorrow. my lord.
unnecessary. Last time you had created unnecessary confusion in,
No,
the
my
mind
lord,
in our mind that CBC has nothing to do with OBC. Every class which is entitled.
I have advertised for OBC. I had advertised for OBC, my lord.
Then?
But wrongly or rightly, I have filed an affidavit in the earlier writ. I had that relying on a press notification, which I admit I was not fair.
Then?
And second submission is that it's a press notification which is not law.
Don't tell us what is law and what is not
I'm
law.
just praying one day only.
Tomorrow, as
Obliged.
requested on behalf of the appellant by way of last indulgence.
Yeah, my lord, copy has not been served. That
I've
is the
served
reason.
already.
Copy.
That is why I am not in a position to say.
I've served the copy.
No, here it is reflected. Copy not received.
सर्विस करते हुए फाइन अकाउंट
Therefore, we wanted to know.
Item 9.
Have you received a copy?
No copy.
Please take a copy and assist us because we won't grant for the time.
Yes, madam. Let him serve a copy in the course of the day, since your lordship is putting it up the
I've
better
already
tomorrow.
served and I will serve another copy.
You are not required to serve any copy on any.
Yes.
All right.
Obliged.
You are free to make your submissions on the basis of what is there on.
Only with judgment I
Don't
want to
do
cite
it.
May please, your lords.
Item 9.
Here I have challenged the order of the Honorable Single Judge at Annexure 16, wherein the Honorable Single Judge dismissed my writ application on the ground that acquittal in a criminal case should be honorably acquitted so that he can get the benefit of reinstatement even if he has been punished in the departmental proceeding. I had relied upon a judgment of the Honorable Supreme Court, where Honorable Supreme Court has directed that that is also part of the record, that acquittal means honorable acquittal. Honorable acquittal, the finding is that the prosecution failed to prove the case beyond all reasonable doubt. That is honorable acquittal. If it
Reasonable doubt is not.
Mr.
No, not benefit of doubt. No.
There are two things.
Yes.
There are two proceedings which are independent of each other.
Right.
Departmental and criminal.
Right.
And the finding will depend on the nature of evidence led in the two separate proceedings. So in the criminal case, you may be acquitted.
Right.
You may be acquitted by giving you benefit of doubt.
Right.
There may be clean acquittal also.
Yes.
But because there was a clean acquittal or giving benefit of doubt, or even because of your acquittal, the finding in the disciplinary proceeding will not be affected, because that finding is based on the evidence led in that proceeding.
Exactly.
So the criminal the finding in the criminal case will not affect the finding
departmental proceeding.
That is the law.
If the nature of the evidence led is different,
no, the evidence see, and then the standard of evaluation is also different.
Right, I don't dispute
in
that.
Criminal case and departmental proceeding.
Right.
So even if the nature of evidence is same in both the proceedings, if on the basis of for the purpose of evaluation, in the disciplinary proceeding, the standards are different.
Yes,
so therefore, you may be acquitted in a criminal case, yet you may be punished in the departmental proceeding.
Honorable Supreme Court has said that if the evidence led, because it's a case of 395, there was a dockery in the bank. I'm a Group D employee peon. The allegation against me is that I did not respond as I should have responded being an employee of the bank. Criminal proceeding started, departmental proceeding also started. In the departmental proceeding, I filed an application to stay the proceeding departmentally till conclusion of the criminal trial, because they rely on the same documents, that is charge sheet, evidence of the IO in the departmental proceeding.
However, that Millers proceeded with my application was rejected, and ultimately the Millers removed me from service, finding on the ground that I was not, Millers, I did not act as I should have acted, being an employee of the bank. Millers. Thereafter, the criminal trial Millers continued. There were 16 Millers accused persons, and it was a case of Millers acquittal, not of benefit of doubt, because Honorable the trial court said that the prosecution has failed to prove the case beyond all reasonable doubt. Not a benefit doubt was never given. Thereafter, I filed an application.
All right. What was the charge in the criminal case?
395.
What was the charge? Charge means what?
There was a doctrine in the bank. So far, I am concerned. They say that I did not respond as I.
That cannot be a criminal charge.
No, criminal charge is they said that amounts to connivance 120B.
Must have conspired, not
Yes, 120B. I'm saying that.
That's not amount.
All
Must have conspired.
All right. So the charge against you was of
120B.
conspiring. And what was the misconduct? Charge of misconduct?
They said that because police has arrested me and I have been put to. Yes, that is the case. Because I absconded because I was arrested. They showed me as absconded.
Let us see the charge.
You yourself said that did not respond.
Charge is. Because you kindly come to.
This is item 9.
Page 94, Millers. Article of charge under major misconduct leveled against the Visication Possessed office attendant, Utkal Gramya Bank.
So part of the counter affidavit?
Yes, page 94. Yes, Millers. 94, part of the counter affidavit filed by the bank, Millers.
All right, got it.
Imputation 1. On 29/4/2011 at 1 p.m., 3 numbers of armed miscreants entered the branch premises of the bank, such and such looted cash of rupees and gold ornaments kept in 17 pockets at gunpoint. Cash and such, which were looted by 3 numbers armed, the ME3, which has been testified by Sri Shimanchal Bhairav MW1, the branch manager of such and such office, and Sub-Inspector Kessinga Police. On the other hand, the charge-sheeted employee has stated no denial of the facts stated in the imputation.
No,
So
you are
it's
reading which page?
Page 94. It starts page 94. I'm imputation number 1.
Wait.
So notices have been issued, notice will go.
Huh.
Someone is appearing for the other thing.
Yes, some are appearing. I don't know whether he will appear. Your Lordship may issue notice.
See, charge number 1 is not a charge at all.
Yes. And 2, he says behavior was not abnormal, absolve me.
Not proved.
And 3rd, on the basis of news item, he says that my photograph was there in the news item. So I've been accused.
Issue notice. 1 week, 4 weeks.
Item 10.
That happened.
Item number 10.
May I plead, Lords? Lords, with my Lord's kind permission and through VC.
Yes.
Lords, in this writ appeal, the appellant is challenging the order, impugned order, judgment dated 24/9/2024 of the Honorable Single Judge in the writ application, wherein the issue was with regard to compassionate appointment under rehabilitation assistance scheme. My Lord, wherein my humble prayer for direction for a direction to the respondent number 2 and 3 was rejected on the ground of delay, whereas the delay is not at all applicable to my case. My Lord, in order to justify the grounds taken in this writ appeal, I humbly crave my Lord's kind leave for providing.
Where is the order, impugned order?
My Lord, that is Annexure 16, my Lord.
Page 58.
Annexure 16. Page 54.
This is WA?
There are 2 connected, one.
Yes, ma'am.
One order. And
Same date of judgment, my Lord, and same respondents also. Only appellants are different.
Is any other appeal filed by you?
No, my Lord.
Was 3 writ petitions?
No, regarding the second, one of the regarding the writ application filed by Arunachal Padhi, that is not challenged.
Okay, all right.
My Lord, may I kindly have a glance to paragraph 11 of the judgment of the Honorable Single Judge.
It's dated 25/2024.
Yes, my Lord, 24/9/2024.
Two nine 2927. Yes.
My Lord, I humbly attract my Lord's kind attention to paragraph 11 of the judgment at page 64. The urgency that typically underscores matters of compassionate appointment has long been extinguished in the present case. A lapse of attributed to both the authorities and the petitioner in order to entertain a claim now originating in 2006, almost 2 decades later in 2024 would serve no meaningful purpose. It is evident that the petition.
Yes, we are not satisfied, Mr.
Lords, the delay, the ground of delay taken by the Honorable Single Judge, that is not applicable to my case, my Lord.
Yes.
In order to justify the grounds in this aspect, I humbly crave my Lord's kind leave to provide a short background of the matter. My Lord, the father of the petitioner, Biprocharan Nayak, while in service under respondent number 2 and 3, passed away on 18/9/2005 under Annexure 1, my Lord.
5 under Annexure 1, died under Annexure 1.
Yes, my Lord. 18/9/2005. And without consuming any delay, I immediately applied for a getting an appointment under the scheme before the respondent number 2 and 3. And since no steps was taken, I made an approach to the learned registrar of cooperative societies in Odisha, who is the administrative authorities of all the cooperative societies, who were pleased to communicate an administrative instruction annexure 3 at page 25.
Yes.
And thereafter, in spite of the administrative instruction of the registrar, since no action was again not taken, we sat on dharana, and for which under annexure 4, we are given the impression that our issue will be settled very shortly by communicating annexure 4 by the respondent number 2.
Mr. Tripathi,
Yes, madam.
he died in 2005.
Madam.
You applied in 2007. Thereafter, what happened for 9 years?
No, madam. In 2005,
I'm asking you, you have to say something, not no.
Madam.
Ah.
Sorry, madam.
Yes.
Immediately within 1 year, I applied.
Yes.
Since
Thereafter,
no action was taken, I represented before the registrar of cooperative societies.
when?
Immediately thereafter. Although I do not remember.
Date. Because there is a letter dated 2016.
No, madam, annexure 3.
Annexure 3.
Yes.
Copy of letter dated
Yes.
17/9/2008.
Yes,
I'm
yes.
asking what happened after 2008.
And thereafter also they did not took any step.
Yes. So what steps did you take after 2008?
Madam, thereafter we sat on dharana, and for which annexure 4.
For 8 years. Dharana for 8 years or when?
Yes, madam. And consecutive communications have been made by the
Output for orders. 1 week. Yes.
Item 11.
And madam, may I be
It'll be listed next week for delivery of orders.
Madam, one more humble submission, madam, regarding the issue as regards to the issue of limitation, madam. The same as per the judgment under annexure 17, the same date of judgment, this issue is answered in favor of the petitioner in that case at page 71, madam. That
So
is
you're relying on that?
No, madam, there is a differential opinion. Same judgment, same date of judgment.
So you're relying on that judgment that similar view should have been taken in your case?
Yes, madam. And the issue of limitation is condoned in that case.
All right.
And the issue of limitation is already adjudicated by this honorable court in a division bench by WPC number 15824 of 2013. As per the judgment that, madam,
15824.
15824 of 2013.
Yes.
Judgment dated 10th January 2014 in case of reported in 2014 1 OLR 777 in case of Pavitraman Pallai versus Registrar of Cooperative Society. That is in connection to Barampur Central Cooperative Bank and Pavitraman Pallai versus Registrar of Cooperative Societies.
All right.
And at page 71.
So both the cases, same point.
Same matter.
All right.
Item 11.
Deeply.
On behalf of Mr. Jekke Mahapatra, I am praying for next.
Why did you file a mention memo?
List this matter after please, as requested on behalf of the petitioner.
Item 12.
May I please? The petitioner before your lordship is a successful bidder of a stone quarry, having fulfilled all the requisite qualification, but till date the agreement has not yet been executed. Lordship will find that annexure 12 series identical matters this honorable court has disposed of, stating that if any representation is pending before the authorities, that may be considered in accordance with law. Annexure 12 series is the similar order Order, my lords, and election 11 series is the representation filed by the present petitioner, which is still pending before the authorities.
Yes.
That's it.
No, that we will not do.
He'll come up again unnecessarily.
I have taken instruction, my lord, in this matter.
Hmm.
So far, the annexure 12 is concerned that order passed by this honorable court. After passing of that order, the collector has passed an order on 4/11/2023, and thereby is directed for execution of the deed.
Execution of?
Execution of the agreement.
No.
That is a different case.
No, my lord, identical case. Similar.
No, identical, but you are not the petitioner there.
No, my lord.
So what happened in another case? You are saying representation disposed of, so
Same. my lord.
allowed, representation was allowed, so that is why same order should be passed.
Representation was disposed, this court directed the representation to be disposed of in accordance with law. Then the collector therein.
So let them do something in accordance with law.
Yes.
That I claim, my lord. My election 11 series is the representation which is pending.
All right, we will see. 2 weeks' time is allowed for the state to file counter affidavit. Does this matter? 2 weeks, first 5 cases. The opposite parties shall be under obligation to a state to disclose the circumstance in which the agreement has not been executed despite the petitioner having been found L1 in a bidding process. Well, yeah, despite being successful bidder,
My lord, may I submit, my lord, due to a stay order passed by the NGT, the agreement was not been executed.
Mr. Counsel, therefore, we are declining to pass an order for disposal of your representation. They will have to take a stand. Why you were declared successful and they have not executed the agreement? Let us know.
Item 13.
Please, Your Lordship. My lord, in this case, all the petitioners are the medical students, my lord. There are.
Yes, please, sorry.
Item number 12, 13.
My lord, in this case, all the petitioners are the medical students, my lord, and they are got the NEET qualified 2022, my lord, and previously 2021, and they have qualified the NEET examination and but got not the better rank and joined to the BDS, my lord, the SC Medical College. Thereafter 2022, my lord, they are appeared the NEET examination and got the better rank and joining the MBBS, my lord, all over the other medical colleges, my lord. But the fact is that, my lord, when the petitioners are applying for the college living certificate, my lord, the college penalized to 1 lakh rupee, my lord. 1 lakh rupee to deposited as per the clause of the H4 of the guideline of the DMLT, my lord. The page, my lord, page 48, last line, my lord.
Which college is this?
And SC Medical Colleges.
This Cuttack.
Kotak.
Yes. Which page you are referring to?
It's on page 48, my lord.
So you were BDS, you had got in BDS.
Initially, we have got the BDS.
So thereafter you appeared again and for the MBBS.
Yes, my lord.
Since you had joined in BDS, because of that clause, you have been asked to pay penalty.
Penalty.
Okay, show us the penalty clause.
Penalty, page 48, my lord. Thereafter, the page 49, my lord.
He blocked a sheet. Page 40?
49, my lord.
49.
Yes.
My lord. 4-line letter, my lord. However, in case of a candidate selected for a better option of the subject or institution, such penalty shall be relaxed, my lord.
Page?
Page 49, my lord. 4-line after, my lord. Upper of the page.
One line, why are you reading? You read the entire
Page 49.
page.
Yes, ma'am.
49.
First para, last.
See, the last date scheduled for withdrawal, we have force it. Again from-
From here, I started from here.
So yes,
My lord. However, in case a candidate selected for a better option of subject or institution, such penalty shall be relaxed, my lord. Thereafter, the all other petitioners as per the annexure 6, my lord, page 71, my lord. The authority considered 11 students, my lord. Penalized to reimburse, my lord. Page 71, my lord, annexure 6. The authority considering the representation and reimburse the 1 lakh rupee to 11 students, my lord. So I have representing the authority, but our representation not considered the authority, my lord.
how many?
Ma'am?
How many? How many students, how many petitioners are there?
Well, 10
Yes.
petitioners.
State?
Yes, my lords. My lords, I'll seek instructions.
You'll take up the matter tomorrow again.
Oh,
Just
fine.
seek instructions and let us know.
Sure.
And in the meanwhile, if they can expedite it, they should.
Yes, my
Have
lords.
they declined?
No, the representative.
Oh, you have already paid?
Yes, my lord, already paid, and the I am joining the other institutions, my lord, but the annexure 6, my lord, page 71, my lord.
You want refund?
Yes, my lord. Already refund the 11% students, my lord.
Other persons, it has been refunded.
Yes, my lord.
Entire thing or they have reduced? Entire amount has been refunded.
No, 1 lakh, the penalty amount.
You understand, here it is. However, in case of a candidate selected for a better option, institute shall be relaxed.
See, you are relying on annexure 6.
Yes, my lord.
So the candidates in annexure 6, they had not paid. Rather, they were exempted from paying. There is difference. Here, you have paid.
Yes, my lord.
And after having made the payment, you are seeking exemption. Are we clear?
Yes, my lord.
Now you are seeking exemption and refund. So this is the difference. So did you apply before resigning?
Yes, my lord. I have applied for the exemption of this fee, my lord.
When?
Annex the authority, my lord.
After admission?
College. No, after admission, my lord.
After admission in MBBS course?
No, sir, before admission of the MBBS course. When the penalty is imposed by the authority, I have applying for
All
the.
right, seek instructions. So there is no urgency then. It's a matter of refund. 2 weeks time is allowed for the opposite parties. As requested by Lund AG, Lund Assistants, Lund ASC. 4 weeks time is allowed to seek instructions and file counter affidavit. 4 weeks.
Item 14.
Mr. Counsel, just when had you paid?
Hello?
In the year?
2022, my lord.
The year 2022, you had paid the penalty.
Yes, my lord. That I have approaching the authority, but
That's 2
authority.
years.
Yes, my lord. Authority said the.
Item 14.
Here, the petitioners prayed for a direction for deployment of OISA, that is Orissa Industrial Security Force, in the mining area, my lord. Lordship kindly have a glance to page 26. The petitioner is a company, public sector company, undertaking both open cast mining and undergoing minings.
Last week, I think,
Lordship,
we had done the matter.
yes, my lord. Page 26, the request of the petitioner company to the Home Department of the State for deployment of the OES personnel, and the petitioner is also agreed to pay the remuneration, my lord. Page 28.
And therefore they are bound to supply.
My lord, because my lord, it is the duty under the YESC Act, when a public sector undertaking is operating a industry, my lord, then it is to be protected, my lord.
Where is that?
My lord, I am giving OISF Act, my lord, I am giving. Because it is coming within the very definition of the public.
Odisha has its own.
Yes, my lord.
Act.
Yes, my lord. The Odisha Industrial Security Force Act 2012. And the 2F, the definition chapter, my lord, that industrial undertaking in public sector means an industrial undertaking owned, controlled and managed by a government company as defined in section 617 of the Companies Act, and a corporation established by or under a central act or state act.
Is there any OISF in the state of Odisha?
Yes, my lord. Yes.
So file your affidavit.
Yes, my lord. We'll file our.
CISF or something.
We'll file affidavit.
4 weeks time is allowed for the opposite parties to file an exhaustive counter affidavit dealing with the averments made in the writ application.
My lord, one prayer, my lord, the name of Mr. Mahanti be deleted, because since he's in the government panel, he could not appear. Mr. Mahanti name be deleted.
We are not mentioning his name, we are mentioning your name.
My lord.
Item 15.
The petition challenged the order 30th-10-2023 under Annex 6, in which the petitioners sanction of lifting of sand from Dharanga sandbed has been suspended for further orders, my lord. Initially, the petitioner is a successful bidder for lifting of sand from the Dharanga sandbed from the year 2021 to 24-25. And during and he has paid all the dues, royalty, according to the order of the Tahsildar, that is annexed in the opposite panel 4, in which the agreement has been made between the petitioner and the opposite panel 3. And the petitioner has paid all the dues, but during the lifting of the sand in the mid of the year, my lord, that is the sand is not available on the concerned sandbed, my lord. Therefore, the petitioner has approached and filed representation to the concerned authority to.
That's a different matter, my lord. May I submit, my lord? Lordship has Annexure 6 that improved order, my lord.
That we have seen.
31. Page 31.
That we have seen. So you have a no due certificate and then.
Yes, my lord. That is the point.
My lord, no, because that is he has filed a representation to the opposite party regarding the less amount of sand, not according to the agreement, my lord, but not a single reply has been given from the concerned authority. Now, without any giving an opportunity to say the matter, the order has the agreement, that is the tender order has been suspended by the opposite party number 4.
Maybe, but how? What is illegality in the order? What is the illegality?
But that is in the.
You are challenging Annexure 6.
But that is no royalty has been filed according to the, even no royalty has been filed, my lord. They are paid, my lord, but according to the petition, my lord, he has paid all the dues for the year 2021, 22, 23, my lord. But the sand is not available. He has paid the excess amount of the royalty, my lord.
But without giving any opportunity to say in the matter, without any listening any grievance of the petitioner, the opposite party number 4 has suspended the order.
No, but you cannot operate unless you have consent to operate from the pollution control board. You cannot operate.
Yes, all pollution control board and the
Where is it? Where is it?
that is annex minor.
Consent to operate. Where is it?
Annex 1 minor.
Yes.
Page minor. 15 minor.
Yes.
That is the environment clearance of Jharanga sandbed has been received from SEIA Bhubaneswar by the letter number such and such date 30th 11 2020, and the mining plan has been received from the Joint Director Geology Koraput by letter number such and such, which you have been
For the year 2020-21.
It should be periodical, my lord. It should be periodical. As per lease condition, my lord, at page
Yes. Consent to operate is every year.
25, page 25, clause 54.18. It shall be mandatory for the project management to submit quarterly compliance report on the status of the completion of the above stipulated environment safeguards to the so and so Odisha SC Special Pollution Control Board Odisha Regional Office so and so. So he has not adhered to this condition.
My lord, page 16, my lord, that is annex 2, my lord, page 16, my lord, in which the agreement has been made between the petitioner and the opposite party number 3, the Tahsildar. That is that a sandbed in the land schedule given below has been settled in favor of Rajkumar Patra, the second party who was awarded the long-term lease 2021 to 24-25. That is for the 5 years, the environmental clearance.
No, agreement will not.
For 5
Agreement,
years, show us.
T, where it says that the lessee has to pay the entire requisite royalty amount and other dues within the stipulated period. Otherwise, the lease will be deemed to be cancelled.
Get that.
And my lord, most interestingly, my lord, Annexure 5 is not under challenge. The demand notice Annexure 5 is not under challenge. Prayer doesn't speak about Annexure 5, my lord. It is only challenging that restraining order. And unless the dues are paid, it cannot be restored, my lord. That's the sole solution.
You used to have those permissions.
Yes, permission. Hence, your query operation is hereby suspended till no due certificate.
And
from the-
CTO. And CTO.
we do not find any merit.
Will be proceeded. Understand?
Instruction. So that will add to the merit of your case. Your case will be improved by filing counter affidavit.
Permitted to withdraw this, it will file the appeal, my lord.
Appearing on behalf
In
of
the appropriate forum, my lord.
petitioner, after some argument, seeks permission to withdraw this application with the liberty to pursue his remedy before
Under Rule 46, my lord.
appropriate
OMMC 2016.
Appeal.
My appeal.
forum
OMMC 2016, my lord.
under rule.
And stipulated
46.
time may can be given for disposal of the.
No.
First
not
you file.
Otherwise,
under rule
legally-
46 or so. Application is assessed with the liberty as sought for. As withdrawn, liberty as sought. Yes.
Item 16.
May I please your lordship?
Yes.
My lord. May I please your lordship? My lord, this is the on behalf of Mr. Rakesh Sarangi, my lord. I'm appealing. My lord, this is the Biju Setu Yojana construction without following the proper procedures. My lord,
This is regarding what?
Biju Setu Yojana. My lord, it is under the Raselpur Tahsil as a bridge is constructing between the Bhagirathipur to Ujjagbar Road, my lord. My lord, we are
Just a minute.
You're saying there is no necessity for the bridge.
No, my lord, there is no such necessity of bridge over there, my lord.
How can we decide?
My lord, actually, my lord, there is no such. My lord, there is not such construction work order also regarding that also in that some regular division Jajpur work order construction proposal bridge for this. There is no such point over there to be create that bridge, my lord.
You mean to say there is no water body, but a bridge is being constructed?
No, my lord, there is water body, but
You're saying no pond?
No, my lord, there is no such point to be
Oh,
created.
point.
Yes,
Okay,
my lord.
okay. Sorry, I heard pond.
No, my
Okay.
lord.
My lords, if I may.
Seems you have been set up.
My lord, I came to that. I am the social activities, my lord. My lord,
We are not satisfied.
my lord, we are not against.
See, we cannot say it is your specific stand in the writ petition that no bridge is required.
Yes, my lord.
So if we hold that no bridge is required, then all your grievances are met.
My lord, I was. My lord, my prayer is that I am not against that bridge, my lord.
You are.
I-
If you are not against the bridge, then why have you stated that in your writ petition? This is what you have said.
My lord, we just want to inquiry of illegalities of.
Inquiry of illegalities, then everything will have to be inquired into first.
So agreed by the bridge or the approach road?
Approach road, my lord, also that is.
No, you make up your mind. Bridge or approach road? Because for bridge, no land need be acquired. For the approach road, there may be, because somewhere you have stated that Gochar land has not been converted.
Yes,
And
my lord. Yes,
have
ma'am.
you read your brief properly?
Yes, your lordship.
You're not stating properly.
Now just see your paragraph 1. That discloses everything.
Work order issued in 2023.
Yes, my lord.
You gave your representation in 2024.
Yes, my lord. My lord, when it is come to my knowledge, then I'll go to the RTI for the limited informations, and but we are not getting the information we want. We not satisfied that, and then we're apply for the tehsil, that is collector office. That is also pending before your that office, my lord.
We intend to impose cost. The petitioner is trying to abuse the process of PIL. We have read the entire petition.
When did you get your license?
2018, my lord.
2018.
My lord.
Do you hold power in the case?
No, my lord. It is on behalf of Rakesh Sarangi, my lord.
No, you are your client will pay.
Lordship, he's a social activities, my lord. He's a social activity.
That is the problem. He is social activist, he is RTI activist. He learned that there is a bridge which is going to be constructed, and the bridge is going to be constructed without acquisition of land. This is one of the allegations, that no land has been acquired, and then everything is irregular, everything is, and therefore some inquiry, something vague.
Land is not acquired. The person whose land is being used, they are the agreed person. What is your problem?
We have lived here in the same country. We know how the things are how the things progress.
My lord, kindly consider.
A petitioner claims to be a social activist and an RTI activist. The present writ petition in the nature of public interest litigation has been filed. Questioning the decision of the authorities, state authorities, to construct a bridge between Bhagirathpur to Kujibara Road and a service road in the district of Jajpur. So stop. It is the petitioner's case that there is no requirement of bridge in that area, and the state exchequer cannot be misutilized. So stop. In the very opening paragraph,
Lordship.
the petitioner has mentioned.
Pardon,
As,
Lordship, kindly withdraw.
why? These persons should be discouraged.
Lordship,
Where is the question of withdrawal? Let them face. See, in the next case, when he files, he will not make this statement, which has been made in paragraph 2 of the writ application. Next time, he will not make this statement. This is a statement he cannot make anymore. Just see paragraph 2. So therefore, we are imposing cost.
Lordship, I am. Lordship, kindly.
And counsel for the petitioner, after some argument, seeks permission to withdraw this writ application. This writ application is accordingly dismissed as withdrawn. Don't accept such cases. Tell them.
Oblige, Your Lord.
And the petitions have got 40.8%, Your Lordship.
40.8%,
Your Lordship. Petitions are 5 in numbers, Your Lordship, and they claim that they belongs to the OBC category, reserve category. So they claim that the relaxation of 40%, which has been provided by the Indian Nursing Council and which has been subsequently inserted by the Esteemed Council of the DMET in their prospectus. So they claim that they should be given 40% mark for the purpose of participating in the counseling, Your Lordship, because it was 50% for the general and 40% of the reserve categories. Well, Your Lordship, just have a glance over the certificates which the petitioner has got as page 30, Your Lordship.
What is your problem?
Problem, Your Lordship, they, in spite of the fact that they have opted 40% above, they
30%?
40.8%. 40.8%. They have not been allowed to participate in the process of counseling for the purpose of taking admission in the.
Where is which annexure you are referring to?
Well,
which annexure you are referring to?
Well, page 30, annexure 4 series, page 30, Your Lordship.
The certificate.
This is the certificate, cash certificate issued by the competent authority. Very beginning. Form of certificate to be produced. Well, I've got it, that page 30. Top.
You belong to
SCBC.
OBC.
OBC.
No, my lord, it belongs to SCBC.
No. Certificate is other backward class.
First 30, page 30. Page 30.
We will have to hold.
And this caste has been recognized. When this caste has been recognized by the government of India and it has been notified by the Social Justice Empowerment Resolution of so and so dated 8/12/2011, And this petitioner belongs to the OBC category. So far as the petitioner one is concerned, Your Lordship.
No, but whether the state government has declared this caste as OBC or not.
So
No.
number one is OBC, number two
that I have
is
to take.
SCBC.
This is the OBC certificate issued by the state authority.
But this
Revenue
is
office.
applicable for central government. This has been
Government-
issued by the government of India.
Government of Odisha issued by it base 30 mile advert. Government of Odisha top.
Yes.
Government of Odisha revenue officer.
Yes, government of Odisha has issued, but OBC under the
Under the central list.
second one is
Well, second petitioner is this
SCBC.
certificate is given. Case certificate issues ACBC by the government of Odisha.
But one thing.
Second.
All right.
The same authority has given the certificate. So far as the petitioner one is concerned, this certificate has been issued. And page 31 to.
So how do you distinguish between this
Well.
OBC and ACBC?
My lord, I've got instruction, but the last occasion, there was no OBC also were given out prospectus. As per my lord direction, in this, we have already added OBC, and this year also we have added the prospectus OBC to be taken as reservation category. SCBC is not there and we have not given.
EWS you have given some EWS.
EWS,
All right. What is the meaning of SEBC?
socially economically backward classes, my lord. That is
So how SCBC can be out of the larger circle OBC?
But EWS.
my lord, that is there. But because that was not given by in our prospectus, we have not considered. So we may, if my lord wants, because
What is OBC?
Other backward class.
other backward classes. So last occasion, my lord has gone through these things, but my lord has allowed OBC. So we have given OBC, and so his prayer is OBC is not included. We have given the notification again for OBC students to be given the caste certificate for
He
consideration.
has given us the copy of the order passed in 16382,
Yes,
which
ma'am,
is
just-
submitted
Part
that
page
the
30.
DMAT has permitted OBC and
Yes, ma'am.
EWS students.
Yes. We have also notified.
In spite of this.
Again that we have given
these
notified.
Petitioners have not been permitted in spite of this order.
OBC is there, we will permit. That's the question doesn't arise.
You have submitted, Mr. Please look at Annexure 4 series,
Five.
page 35.
Yes, my lord.
Annexure 5, sorry, Annexure 5.
See, there are two aspects. Two aspects. You may be SEBC, but you will have to have non-creamy layer certificate to have the advantage of reservation. Otherwise, you cannot. So only scheduled caste, scheduled tribe candidates, they are not required to have this. For all other classes, SEBC or OBC. So OBC may not be entitled for reservation if he does not come in, if he comes in creamy layer.
Well,
All right.
well, I do follow.
Equally, if SEBC is not a creamy layer, he will not be entitled for reservation.
Obliged.
So here the certificate which you are relying on, this government of Odisha,
Yes.
ACBC, there is no mention that.
Well, last para.
What?
Page 30, last para. This is also to certify that it does not belong to the person section's creamy layer mentioned in column 3 of schedule.
This
To,
we'll have to decide. It's a confusion.
it's also not the, it has been specifically stated in that certificate.
So do you have any reservation rule or law or act, whatever?
Prospectus only we have given for that, we have not given.
Prospectus.
And
It's
another
prospectus, but we will have to decide whether SEBC is OBC or not. And we don't see any reason why ACBC should be excluded.
That non-creamy layer certificate.
So are you declining them on the ground that they belong to SCBC?
Yes, my lord, not OBC, the SCBC we have not allowed. Or SCBC, my lord wants, so we can. Because you have given, last year we were not giving OBC, because my lords give a direction, we immediately implemented and give all OBC students to get admission. As for that order. As for the INC guideline, my lord has given a direction.
Not a question of my lord wants, if
Yes.
if your guidelines require that. you should
INC
give-
guideline.
Yes,
Oh, complete.
just given that annexure 36.
That order, your lordship, I have annexed at page 35.
That is not the code.
They have not included OBC in spite of the fact that the INC provided the they have not included. After a lot of litigations before your lordship and as per the your lordship decision, they have included the OBC category by way of Coringian. OBC category. And they are now saying that my colleagues say that the ACBCs are not OBC. If other 4 petitions will be considered.
Take up. Who was appearing in this case? In that case, the other case, which was taken up in the morning?
Item 8, I think.
Eight was.
Eight.
Yes.
Sir, Das was there.
Sir, that's what.
You also, Mr. Panda, you also try to assist the court.
Okay.
All right.
KZ note. It may come along with item 8.
Is this matter tomorrow to be taken up along with item number 8? Well,
Item number 18.
Published.
My lord, one passover may be
Conducted.
yes. Next. No, Passover means Passover. Later.
Item 19.
Item 19, Malats, we have filed an IA today. Malats, may I pray it be taken up tomorrow along with the IA, Malats?
Let us see. What is your IA?
IA is for the keeping the lease deed in abeyance, Malats. Annex 9 under abeyance.
This is PIL.
No, Malats.
Right.
This matter relates to a stone quarry, Malats.
Single qualified bidder.
Yes, Malats. The legal point involved is the acceptance of a single qualified bidder.
So appeal, it has been rejected.
Yes, Malats.
Were you before this court earlier?
No, ma'am.
No, Sukra or Ram. Sukra or Ram. Okay.
Where is the law that single bidders shall not be allowed?
These are settled by two judicial decisions.
Oh, no, where is the law? Judicial decision we will see. Give us, give us.
Yes. Page 3, para 5. The purpose of not accepting the single tender or bid is to ensure competition among the bidders. The exception to accept this is now provided only case of retendering, where in the initial tendering process also there is a single bid or tender. Thus, the object is very clear that there should be competitive bidding between the parties before the tender is accepted. Merely because the 5 tenders were filed, it would not mean that it is a case of multiple tenders unless 2 or more tenders are found to be in order and accepted. Similar view was taken by the division bench of this court in the case of Arun Kumar Manti versus State of Odisha, where only 1 tender was found to be valid and others were rejected on technical grounds. Then the technical evaluation committee had recommended for approval of next higher authority, and consequently the collector rejected the said developer and directed for retendering. Found that the action to be correct, as it held that the tender of the petitioner had been reduced to a single tender.
Yes.
My Lord and Friend is relying upon Annexure 2. My Lord, I have to take instruction on that, my Lord. Because it is their stand that as they paid the money by the check, that is rejected.
Yes.
I have to take instruction on that, my Lord.
Once my bid is rejected, it comes down to single tender, my lords. That's
No,
my
but
whole
you were
case.
a qualified bidder.
No, my lords. Because I have submitted a check for EMD, it was not accepted. So I was not a qualified bidder. Now accepting this single tender, they could not have proceeded with. They should have retendered the Sarata.
Is that the rule?
Yes, my lords. That is what the settled principle of law is. By the judgments which I have provided to your lordships, a single tender cannot be accepted. In the subsequent retendering process, if again a single
there
tender,
is difference
my lords.
between the judgment which you are relying on
Yes,
and the facts of the present case. There, the tender was cancelled. The situation was just reverse. Single tender was given and that was cancelled. All right. Here you want that order was under challenge. Here that order is not under challenge. Here grant of lease is under challenge. That is the difference.
My lords,
So
kindly refer to the second decision of this honorable court I have given, that is WPC 25993 of 23, my lords. Kunjatirki versus here the lease deed was also cancelled, my lords, in view of the settled position of law. Having heard last page, my lords, having heard learned counsel for the parties and perused the materials available on record, we are of the view that since the opposite party number 5 is a single bidder, as has been admitted by the state opposite parties as well as opposite party number 5 itself, the said lease deed in favor of the opposite party number 5 cannot sustain in the eyes of law and is liable to be quashed in view of the law laid down by the apex court as well as this court, CWA Soma Consortium and Debabrata Samal and Rangadhar Pradhan Supra. In view of the above proposal, the lease deed so settled in favor of the stands quashed, the writ petition is accordingly disposed of.
So let us see the rule. OPWD code.
That single tender thing, that is to in order to obtain a competitive price.
Yes, Manoj, that's the whole
So is this
point
price
of-
very
Yes,
low or something?
Manoj,
Is this price low?
very low, Manoj. The nearby, that's why I've annexed annexure 11 as well, showing the nearby queries which have gone on for rupees 550. However,
Let us see OPWD code. Where is rule 29?
Rule 29, Manoj, is
OMC. Give the mining
OMMC rules,
Mining.
2016.
Law of mines.
No, you are relying on which rule?
I'm
You are relying on a judgment.
I'm relying on the settled position of law by this honorable court as well as the apex court.
First tell us the rule.
That judgment of this court is with reference to rule under the OPD, WD code or whatever.
That's in regards to actually, Manoj, with regards to tenders. Even though that consideration has been to the OPWD rule, it is
Mr.
with
Counsel,
Manoj.
you are wise enough to understand
Manoj.
that if a law is laid down by the court,
Manoj.
that is laid down in view of the rules or whatever law which is considered.
Manoj.
Accordingly, we would also like to consider what is the position here.
Manoj.
Law we have understood that there should be competitive price bidding. But where is that provision?
No, that OMCC rules and OMC rules. There is a law that. Higher officer.
Where is that?
Manoj, may keep it on Monday. I'll get the rules. I'll get the rules and satisfy a lot.
Mr. Tripathi, which is the rule which says in case of a single bidder, they have to take permission of the higher officer or get it confirmed.
Counsel for the petitioner is not prepared. List this case on. As requested by him, list this case on. 1 week.
Item 20.
Manoj, Monday, Monday.
1 week.
Deeply.
Item 20.
May please, Your Lordship, praying for Passover, my lord.
1 week.
Item
Why did you make a mention for early hearing? This was mentioned. It has common mention slip. 1 week.
Item 21.
The petitioner in this situation challenged the RFE under Annexure 2, but the authority invited the RFE and challenged on 3/4. One is they violated the own principle of law. Second, they have not followed the principle which are followed earlier. And third, they have also floated the RFE arbitrary. Your Lordship, kindly have a glance to Annexure 1 first. This is my certificate of MSME. Page 20, my lord.
Yes.
Your Lordship.
All right, we'll see.
Therefore, Your Lordship, kindly have a glance to Annexure 6, page 79. There are some relaxation given by the government to the MSME. There are 4 relaxation: exemption from deposit EMD.
Yes.
Second, relaxation from annual turnover criteria, relaxation from prior experience criteria, relaxation from performance equity deposit such and such. At this point, your lordship kindly have left to RFE, which is under Annexure 2, and the relevant portion is page 31. Yes. Eligibility conditions. May I please, madam?
Just a minute.
Madam.
Yes.
Madam, page 31. Page 31, 3-1, madam. The Annexure 2 starts from page 20. The relevant page is page 31, 3-1. Eligibility conditions, requirements.
Page 31.
Madam. The page 11 of the bid document. Madam. The second clause is EMD. The EMD amount has been fixed to your lordship, second line 20,000. That will straightway come to last 3 lines of the EMD. May I please, madam?
Yes.
Madam. The EMD shall be exempted to the MSCB unit startups as per the extent policy appropriate policy of the approved government as is to your lordship. There are performance security. There is no relaxation in reference to the performance security. The 4 is financial evaluation.
Where are you reading?
Page 3. Clause
Page
3.
11, 3.
3. They have given the exemption in respect of the EMD.
Slowly.
Sorry, ma'am.
Yes.
But they have not given any relaxation in respect of the point number 3 and 4. At this point, this ordinate bench of each honorable court had ordered that 2010, 22-10, 24 has already rendered a judgment, my lord. Sorry, rendered an order and vaccine.
So the letter you were referring to of the government,
My lord.
there they asked that in that respect of that RFP.
No. This is addressed to me, my lord. In my query,
Annexure 7.
my Annexure 7 is another RFP.
That is what I'm saying. You are saying
Sorry,
no.
ma'am. Sorry.
So that was in respect of another RFP. Pursuant to that letter, you were included in that list or not?
My lord. That
was of last year.
My lord. And basing on the Annexure 6, coordinate of bench of this honorable court passed the order on 22-10-24. After considering the counter filed by the state government.
So what was this tender about? This RFP about?
RFP, your lordship kindly have a glance to page 24, scope of the work.
What is that?
That is for broadcast, online broadcast.
Empanelment.
Empanelment for online broadcast of the government programs.
And when you were referring to this annexure 6,
My lord. The same document has been relied by the coordinate bench, my lord.
no,
My lord. The 27, 12, 2023.
See,
The
this
lord will
letter,
find second page of the order.
see, this letter is not permanent. This letter is only for one RFP.
No, my lord. Because your lordship will find the in their petition, your lordship, the that is under annexure 9, my lord. Challenging the annexure 9, one focal hub was challenged. Approach this honorable court.
That letter which you are relying on, you are saying that has been issued in respect of that RFP. Specifically, it has been stated there.
In criteria in reference to RFP, my lord, not particular RFP. My respect to submission would be in respect of all the RFP.
No, please see.
My lord. I am placing, my lord. Inviting the
in view of this policy.
Yes.
In view of these policy provisions, bid of such and similar such local MNC such and such may be provided with the above mentioned relaxation in the RFE for selection of production house agencies for production of audiovisual contents rotated by such and such, subject to mentioning of quality and such and such. That is the notification they are relying.
No.
Therefore,
Yes,
it was because you went before them and represented before them, then the communication has been made.
But
this relates to that only.
But the guideline is just in respect of the MSMEs, madam.
This is general. This is general. This is general. This is additional.
So if you have relied on those OGFR and MSME department notification in respect of EMD, why not for the other?
My lords, first of all, the annexure 6 specifically mentions the RFP, which is at page number 81 on 80 onwards. And second, this is a new.
That says in view of these, they have referred, but the other things which the other references regarding the startup policy as well as the MSME department notification, that is for all the tenders.
My lords, this is
he had gone there because in respect of that RFP, it has not been mentioned. That is why the government clarified. But here again, you are doing the same thing.
My lords, because this is a 2024 RFP, and in that few exemptions have been given to.
Exactly. Why few and why not all?
That's a, I'll take instruction, but that's, I think, is a policy decision. I'll take instruction.
No, that may be a policy decision, but whether this policy has changed, the policy which have been referred to in this communication, like Orissa procurement so and so policy, all that is fine. 3 weeks time is out for the state opposite parties to file counter affidavit. Yes.
That's not finalized.
But if it is finalized, you can, oh, this is a tender.
Minor.
But can't you be added subsequently in case you fulfill? I don't think it is like that only one person will be selected. It is going to be a panel.
But till today, it has not been finalized. Other may I minor.
Even if it is finalized, will you be prejudiced in any manner? Because if you qualify, they will add you.
It may take some time for finalization. That is my fatigue.
3 weeks, yes.
Item 22.
Other may I press one thing. In view of the judgment of the coordinate bench, my lord, your lordship may direct for consideration because the coordinate bench has
22.
Which is coordinate bench?
Coordinate bench of this unknown court.
Single bench.
What is the core? What do you mean by coordinate?
This unknown, the order passed by, and that has not been challenged, my lord.
Coordinate bench means
Myler, I understood Myler. But that has a possessive value, subject to correction.
2 weeks. 2 weeks. Can you do,
Madam, we
madam?
get instruction 2 weeks.
May I please, Your Lordship? The matter relates to admission into ITI training courses, my lord. In the instruction have been.
Which item is this? 42. Yes.
My lord, the matter relates to admission into ITI training courses, my lord. The petitioner has been appearing regularly and admitting the students, but by the answer 4 series, they have been stopped to take admission into ITI courses. In respect to some other cases, Your Lordship passed the interim order and putting it to another date, and the similar order is also wanting in this case also.
But those were the institutions.
My lord.
Those similar orders were in respect of those institutions.
Several institutions.
Who are you?
I am owner of the institution. अरे देऊन काय
When did you file this writ petition?
We filed on 13th September 2024, man.
And that name you have added subsequently. Anjan Kumar Naik, secretary. Bhadrak, what is this? To its secretary, Anjan Kumar Naik again. What is this?
Bhadrak Institute training in the page 1. Represented through the secretary, man.
No, go forward. Must have tried to make it good. Just number 1.
Should have done that. Oh. Where is Madam Patnaik? Is there? No.
She's under some personal difficulty.
All right. Because these cases, she was there. And as far as I remember, the show cause had been given to the institution. You're supposed to reply within a particular date.
My lords, at annexure
the institutions which had replied within the particular date, we granted them opportunity to admit students. Others, the matters are pending, but no order as to admission.
See, there is no interim order. This is not an interim order. You do whatever you want.
Well, this may be connected with the other matters. So
that we can do. Otherwise,
it's a similar matter. Interim order, Your Lordship has passed.
It is not an interim order. Selected.
Acha.
That is subject to when.
These are given in respect of the one who had.
We will just discuss. Plus this writ petition along with, what is the number? What is the number of the other test along with?
That is mentioned.
The 10th, thereafter it has probably been adjourned. Just check one number.
My lords, if I may, one submission. My lords, order dated 19/9/2024, therein specifically mentioned that those cases where without any opportunity was given before the communication, but here in Annexure 4 series, where it was disallowed for the admission, time has been given to the petitioner to file the objection. That's the reason this will stand in a different footing.
So we are not saying anything. We are just directing listing of this matter along with nothing else.
So no date.
So, fix a date.
List this on a date along with those.
In the meantime, if any further date will be extended, I should take opportunity.
In the meantime, if further date will be extended, I should avail the opportunity.
Yes.
Item 23.
The writ petition matter has been filed for matter seeking a direction to tender authority to issue the work order and to accept the GST quoted price and the service charges submitted by the petitioner matter. What happens in this case matter? The petitioner along with others have been selected in the technical bid for the financial bid. And in the financial bid, the petitioner has been selected as the lowest bidder. But the tender authority has not issued the work order.
Where is the obligation?
And what earlier, I have approved this annual code to 2 times, despite order of this annual code under annexure 4 and 11, the tender authority kept silent over the matter till date since last 6 months. The order have not been complied with. In the meantime, one administrative action has been taken under annexure 13, that is also under challenge. In that annexure 13, at page 46, annexure 13, they have directed to inform you that district selection committee meeting for finalization of tender process papers for selection of human resource service provider for engagement of CCS and LCCCS, But still the order of this annual code 2 times, are pending before the tender authority without any finalization. What happens, both orders passed in the writ petition have been communicated to tender authority, but then the orders passed by this annual code, have already been communicated to tender authority from time to time. But instead of referring to this order of this annual code, they have so moto initiated a miscase under answer 7, and directed the petitioner to participate in the hearing of the case.
Participate
in the hearing of the case.
Which case?
They have not mentioned in the honest and but they have not referred. Nothing has been referred. Annexure, the Lordship kindly see Annexure 7. But till that, no order having been passed, neither on the miscase or nor they have neither complied the orders of this annual code passed under Annexure 4 and 11.
Let us see Annexure 4 and 11.
Yes. Annexure 4 at page 23, that is the operating portion of the order.
Yes.
Writ petition directing the authority to consider and dispose of the representation filed by the petitioner by the Annexure 3 and pass appropriate order taking into consideration Annexure 4 as early as possible within a period of 3 months.
So this is one order.
Yes, ma'am. But within 3 months they didn't take any action.
This is one order passed in 2024, April 2024.
Yes.
Where is the second order?
Annexure 11, ma'am. The operating portion of the order as started from page 42.
Yes.
We dispose of the writ petition directing the OP number 2 to take a decision on the representation filed by the petitioner by the Annexure 10 and pass appropriate order in accordance with law within a period of 3 months from the date of production of a certified copy of this order. The order shall be communicated to the petitioner by the OP number 2 within 2 weeks of taking any decision, within weeks of taking decision.
Come here and extended the time.
No, my lord. Because my lord, they have issued under Annexure 13 letter dated that is 30/10/2024.
So was there any direction that no hearing should be given to you before passing over orders?
Because I have selected as the lowest bidder in the financial bid.
Therefore, they were under obligation in view of the order of this court that they should not hear you. They could not have heard you before passing an order because the order was to consider your representation and dispose that off.
But they have stated that the meeting will be held for finalization of tender papers, my lord. The tender papers are already been finalized, my lord. And I have been selected as the lowest bidder in the financial bid, my lord.
Likho. The petitioner in the present writ application is seeking quashing of later dated 287, later number 2872 dated 30/10/2024 issued by the District Welfare Officer Bolangir, whereby a district selection committee meeting has been convened for finalization of tender papers for selection of human resource service provider. Stop. It is the petitioner's case that since it has already been declared as L1 upon opening of the financial bid in the presence of selected bidders, there is no question of the district selection committee meeting again for finalization of tender papers. Stop. Next, when counsel appearing on behalf of the petitioner has drawn this court's attention to the orders dated 12/4/2024 passed in WPC number 8858 of 2024 and dated next 11 and order dated 18/10/2024 passed in WPC number 25983 of 2024, whereby the opposite parties were directed to dispose of petitioner's representations. First off, the petitioner had approached this court by filing the aforesaid writ applications, raising a grievance that despite his selection as L1 bidder, the opposite parties were not executing the necessary agreement. Stop. It was in that background that this court, by order dated 18/10/2024 in WPC number 18/10/2024, had disposed of the petitioner's representation writ petition with a direction to the opposite party number 2 to take a decision on the petitioner's representation within a period of 3 months. So stop. Soon after passing of the said order dated 28/10/2024, the 28, not 28, 28, oh, 18, 18/10, 28, 18, by later number 30/10/2024, the petitioner was asked to participate in a meeting convened by the district selection committee for participate in a district selection committee meeting for finalization of tender papers, which the petitioner has challenged in the present writ application. I'll stop. In our opinion, the present writ application is thoroughly misconceived. There was no direction issued by this court to act upon the petitioner's selection as L1 bidder. Rather, the direction was to consider the petitioner's representation. Stop. The petitioner cannot claim by way of right that once he was declared L1 bidder, comma, the work ought to have been awarded to him. So stop. Apparently, we do not find any merit in this writ application. So stop. The petitioner shall, however, did you appear on 1611?
Yes.
You appeared.
My representative has appeared.
The petitioner is said to have appeared before the said district selection committee on 16/11/2024 to its represent 6/11/2024 or through its representative. So stop. Next. This writ petition being devoid of any merit is dismissed, but with the observation that the concerned opposite parties shall be at liberty to take appropriate decision on the point of selection.
Some dispute regarding acceptance of your GST which you have quoted.
Yes,
That is why you have made a prayer that GST also will
Yes.
be accepted. or what?
Yes.
Whether the work in question is to be awarded to the petitioner or not in accordance with law. Okay, blacklisting or something.
The number of that is what they call everybody. This one is another regarding acceptance with GST, so that one way.
Yes. Yes.
The orders of this route have not been complied till date, my lord. 2 orders are there, my lord.
That we have
Still
seen.
pending.
Item 24.
So here the petitioner is a proprietorship firm dealing with service providers. Pursuant to the notice under annexure 1 noted by the Konark NSE, the petitioner applied, and under annexure 2 it has been selected. And under annexure 3 the agreement was executed for a period of 1 year. And your lordship sees page 15, clause 4, that the agreement shall automatically expire on completion of 1 year unless extended for 1 year, further 1 year, based on satisfactory performance. But the petitioner is performing the persons provided by the petitioner, the performance is satisfactory. And that will be evident from annexure 4 series below.
So, what do you want?
I had made an application for extension of that 1 year, for the period of 1 year. That is pending.
What is this?
And the period is going, first 1 year is going to elapse on 15th.
All right.
And my performance is not satisfactory. And annexure 4.
That they will decide that. We cannot guarantee.
Well, if your lordship sees annexure 4 series, we have provided one driver and one sanitation supervisor. That is in the month of September.
You pursue your remedy there. They will decide.
Yes, that we had applied, Lord. That
see,
annexure
Mr.
5. Annexure 5.
Just think of the difference between you and your employer.
Well,
you want to extend work and they want to take. Who should be more worried? So they will take, if they are happy with you, they will allow you to continue. If they are unhappy, they'll don't allow. So they are also equally interested.
For you, that annexure 5 may be disposed of by
the present rate
your lordship
application.
and direct them to dispose of by.
No representation. You may pursue your matter. And where is the question of pursuing? You may pursue. That liberty we can give.
Under clause 4 of the agreement, your lordship has seen that.
Mr. Counsel, we entertain writ petitions only when you establish your legal right. You don't have any legal right to continue after November 2024.
Yes.
Now you are saying that we should direct them to consider your representation. That you pursue. Why should we direct?
So that legal right will flow from annexure page 15, clause 4.
That we can decide. That we can decide right now. If you have any right, we will surely enforce.
At place that page 15,
right,
clause 4 of the agreement.
There you may be correct.
That the agreement shall automatically expire on the completion of 1 year.
Yes.
Unless extended for further 1 year based on satisfactory performance.
All right.
Did they say that my performance is unsatisfactory?
All right.
That is what my prayer is.
Right.
And a perusal of annexure 4.
Which clause?
Clause 4.
All right.
Page 15.
All right. So we should pass on. This writ application has been filed.
Only one thing I will point out.
Nothing else. The petitioner is a registered proprietorship firm under Odisha proprietorship rules and said to be duly registered in the office of IG Registration Odisha. An agreement was entered into between the Konark, NSC Konark District Puri on 15/11/2023. Puri and the petitioner on 15/12/2023 for providing for deploying personnel to work at Monarch NSE for a period of 1 year. 1 year, said period of 1 year is going to expire on tomorrow. First off, the present rate application has been filed seeking direction to the opposite parties to extend the period of contract for further 1 year because the petitioner's performance has been satisfactory, relying on clause 4 of the agreement.
Clause 3 also. Clause 3 also.
Clause 3 and clause 4 of the agreement. First off, clause 3 and clause 4 of the agreement read this, paragraph 14 second. First off, the aforesaid provisions under the agreement. In the court's opinion, the aforesaid provisions under the agreement do not confer any right upon the petitioner nor any obligation on the opposite parties to extend the period of contract. First off, it is open for the opposite parties to extend the period or not, depending upon or not, which is totally at their discretion, depending upon the requirements. First off, this court exercising writ jurisdiction is we are not inclined to entertain the prayer made in the writ petition requiring the opposite parties to extend the period or period. It will next, it is higher open to the petitioner to convince the opposite parties to extend the period based on its satisfactory performance. Its application is accordingly dismissed with the aforesaid observation. Yes.
Item 25.
That is not annexure 5 is my representation.
Yes.
Item 25.
Already in item 25, the contempt, the opposite parties were required to comply with the order of this honorable court, which, my lord, in fact, after the consecutive inquiry, we found that the honorable court directed the intervener, opposite party, private opposite party. He said that it is his land. And at that time, it was, my lord, assumed that as if she has the land. And to take that land, collector was directed for construction of the road. Now, after the inquiry, we found, my lord, the land belongs to the government. We want resumption of the land to the government khata, because if we act upon this honorable court's order, then the private party will be benefited, land grabbers will be benefited. So we are seeking modification of the order which was sought to be implemented, my lord. We have already filed, my lord, drafted the matter, and probably on today, we will file that modification application, and by Monday, we will also file the so-called affidavit.
Why modification?
Modification of the order, which is sought, which we are
21/1/2024 order. If you also kindly see the order number 16.
You can see
24/1/2024.
Yes. What is the finding?
So that order, paragraph 8, if your lordship looks at, para 8 of that order. Having heard when a counsel for the parties on going through the records, since the dispute relates to construction of a road of 276 feet on a land which belongs to opposite party number 4. Once opposite party number 4 has expressed his willingness and interested to donate the same in favor of the concerned authority, there should not have been any impediment on the part of the state opposite parties to receive the land in question, go for construction of the road. Therefore, this court is of the considered view that state opposite parties should take immediate steps to receive the land from opposite party number 4 and go for construction of the road, which has not been undertaken for so many years. In view of such position, the court directs the collector both to look after the issue by taking land in question from opposite party number 4 and go for the construction of the road in question in the interest of public at large. And needless to say that entire exercise will be done within a period of 3 months. And land has already been donated. By number 4.
The land which does not belong to opposite party number 4.
Now they say.
How can that be donated?
So at that time, the record of right, everything was produced and it was verified.
Maybe, but they may
But
still
if
review.
the land doesn't belong to OP number 4.
Therefore.
Sir, one thing, let me kindly keep it in mind. If it does not belong to the OP number 4, belongs to the state, there is no difficulty in constructing the road.
Yes, my lord, we won't do that, my lord. We'll do that.
Road has to be constructed. We are
We'll do that.
concerned about the road.
But we will do that. So, we will seek only modification of the observation that land doesn't belong to the OP number 4. Land will belong to the government as per.
But what about the construction?
276 feet is only remaining, my lord. We will construct it. Only lordships modify.
What time?
No.
That's a different thing.
Keep probably if further in future.
See, you have two options, my lord. You may file review application, may not file. Modification we shall not entertain. If you want, you may file review application. We shall entertain your review application only after you start the work.
Yes. I bow down, my lord. That I will ensure.
Then we will take up your review application, and if you don't start the work, then we will punish you in this contempt.
No, I ensure, my lord, work will be started within a week, my lord.
Within a week you do it. We are listing it on
week after.
Next week.
Observe that, but indicate that in the order so that they can comply.
Definitely.
Let us see. We have now understood.
Yes.
Let us see. We are not making any observation.
All right.
On the next day, if you don't inform the court that the work has been started, then we shall initiate contempt.
I bow down, my lord. 100% I will ensure initiation of the work, my lord, but subject to that observation should be your lordship.
Observation will come after you file review application. We shall not entertain your review application.
That is this legal impediment, my lord. Only because
what is the question of legal impediment?
Because private party is coming to the picture, my lord.
Private party is doing nothing.
And we are in mutation appeal before the sub-collector for resumption of the land, my lord.
All right. So you construct who is stopping you?
No, nobody is stopping. Probably, my lord, some record were showing that it has mutated.
Property, if it is state property, do it immediately.
Yes. It's a public interest litigation, we will do it.
The Learned Counsel appearing on behalf of the opposite party, state of Odisha.
Both.
Learned AGA appearing on behalf of the opposite party, so and so states that some facts have emerged as regards title of opposite party number 4 to the writ application over the
number 13684 by 2024
over the land in question. To stop. He has, however, land in question he submits that the said land in fact belongs to the state government. So he has further submitted that in any case the work for construction of concerned road, bracketed 276 feet.
276 feet,
comma, shall start within 1 week.
1 week,
1 week. So stop. This matter on Thursday. Within first 5 cases. First stop. If
we'll file affidavit regarding that.
For some reason the work does not start by the said date, comma, the executive officer, notified area council, Bodhgad, who has to construct the chief engineer?
Collector and the NSC executive. Collector and the NSC executive officer.
The chief engineer.
The collector both, direction was collector both.
Collector both shall be required to be personally present in court. Yes.
Item 26.
we are not pressing the contempt. The main writ, of course, has to be heard.
One senior counsel appearing on behalf of the petitioner does not intend to press the contempt application. Press UNTC 6077 of 2024. And the contempt case stands stopped accordingly. Stop. This is about what?
The writ is pending, Your Lordships.
This is
Your Lordships, what really had happened is the municipality had given us, granted us a right to construct land over a particular property. And there was a litigation which happened without making us party. And that's a reported judgment where the court found that the property actually belonged to the works department and the municipality had nothing to do over it. But this happened after around 12 or 15 years of we running the whole thing and constructing and whole. And therefore we came before in another writ application, showing the various judgments that we can challenge if we have not been made parties, not heard. So, and there, Your Lordships, of course, the court, looking at every circumstance, has made an order that you find an alternative place for them. That is how the matter was pending. When meanwhile they ensured that the whole thing is removed and everything was literally bulldozed.
when?
So even if they can come up with the instructions of order number 9, that the alternative site, I think the whole thing can be resolved.
1 week after.
1 week?
1 week after, I will seek instruction for filing affidavit.
And here I'm appearing for other municipality, my lord. Am I audible to my lords?
Yes.
But I'm appearing for the OP number 4. So lordship will see that 2006.
More audible than
the physical appearance. My physical appearance in the court.
Yes. Yes.
In fact, this property belonged to the state. Recorded as non-injury drain, something like that. Lord. This is plot number 349.
Non-injury means the land between the road and the nala.
That's right, Lord. Non-injury is the land between the road and the private properties, private land, which is used as drainage and passage of water, except drain water, wastewater. But over that area, municipalities.
We will take up after recess.
My lord, pardon, my lord. Item 25, lordship may also require personal appearance of that executive officer. Direction may be given to both collector as well as the executive officer, because the executive officer is party number 3. Both may be directed.
Item 35 will relating the court managed matter admission. I am for the first time in the matter, you will have to hard. May create it from 1 week so that I will make a note and give it. I will inform them.
You will have to make a mention first before before Mr. Mohanty.
No.
Make a mention, go with a slip for adjournment. If he grants you adjournment, then because the matter is pending since long. And
Since I first time with a lot of documents.
please convince him.
So let this matter come 1 week after, because I'm very awkwardly placed after
All right.
lunch.
As requested by Mr. Rath, and senior counsel, list this matter on 1 week.
1 week after.
Contempt is dropped.
Contempt is.
knows my predicament. There's a lot of documents and references there. I have not gone through. I have to make a note.
All right. 55 go. I have requested
Particular date and time will be given. If
on
not
behalf of
next
the
week,
opposing parties.
7 days after also. Very good.
Matter on 1 week to be taken up at 2 p.m.
Maybe pardon my lord. Maybe pardon my lord. Item number 38 with my lord and senior Mr. Samal, my lord. My lord, this matter may be taken up, I pray, next week within first 5 matters.
Your lordship, previously passed an order, it will be taken up within
First 5 matters.
Can it be taken up on next Monday?
That's a
or
request.
Tuesday?
Humble request, your lordship.
And you have prepared your notes so well.
Yes, yes.
So it's that will be very useful for me,
Yes.
I have to.
for us.
Item 33. The first, can it be taken up sometimes week after?
Huh?
38, my lord, out.
38. 38. Again, within first 5 cases.
34.
Just
What is 33?
33, that matter also fixed. And I have prepared a paper book I have also given, that trust matters. Yes. A paper book I have prepared, I'll give a copy to my learned friend also. Only 2 weeks after, so that
2 weeks.
My lord, 34, substitution is necessary as is respondent 1. I am asking 2 weeks time. 34.
34. So let the matter be called.
Steps have not been taken. You could ascertain the name, is he taking that?
Item 39.
This is an application, my lord, of a party aggrieved who was not a party in the earlier application, and an order has been passed ex parte, and my lord had directed the state to file a return. They have filed a return, and they're supporting the case of the petitioner, my lord. My lord, the short point for consideration here is, my lord, that there is a Orissa PWD code, my lord.
PWD code there.
Yes.
There is a code, is it? Some code,
Does it say that that PWD code that it only has to go to registered association?
Yes, registered association.
So,
Yes.
let me see.
And yes. And my lord, it has to be confined to that district. And that's a policy decision which has been given at the behest of the cabinet, my lord. And this is part of the code.
So let us see code which.
Yes. Appendix 7, Volume 2.
Volume 2 then. I
Not
got
7,
it.
8.
Volume 2, Appendix 7.
Appendix 8, my lord.
Appendix 8. Yes. Page.
Is my lord having the thick book or the short one? Well, then I will take, I'll also just that.
Page 2.
Yeah, I'll just give that, my lord. Because I have that bigger one, which may not be, the pages may not be the same.
We don't have that.
Yes, that doesn't matter.
20.
Yes, 280.
Yes.
Page 280, my lord. In that.
Yes.
Contractor registration.
Yes. PWD Contractor Registration Rules 67. Yeah, just.
Yes.
Yes. 1, my lord. These rules will be shown also. No person shall be awarded a contract except with permissible limit or job basis under any wing of the PWD unless he has been registered as a contractor in accordance with these rules and has obtained a valid certificate of registration thereof.
Yes.
And, my lord, this, my lord, is confined to one aspect that it will be within 5 lakhs. My lord, what happens? These jobs are basically jobs in the place of where these sluice gates are, my lord, there. So since sluice gates are there, my lord, what they do is.
Sorry for interrupting. Where is that within 5 lakhs?
Yes. 9B. 9B, my lord.
Quoted page 6.
Page 6, I've quoted it, my lord.
9B.
Yes.
9B says There's no 9B in this.
Every registered.
Huh.
9.
Notice inviting tender. Notice inviting tender, my lord. It
No,
opens.
PWD code.
Yes.
Yes, where?
Volume appendix 9, my lord.
Appendix 9, you said appendix 8.
Yes. Number 8, my lord, is the contractors association.
Then appendix
And
9.
the
Appendix 9.
maxima is 9.
Yes.
This is an amendment in 9B.
Yes.
Notice inviting tenders for works costing more than 10,000 up to 5 lakhs should be circulated among the local office.
Yes.
A copy of the NIT should be sent to the Contractor Association, all divisions of the PWD within the district concerned, and the Superintendent Engineer's office.
Appendix 9B, you are referring to appendix 9B.
Yes, my lord.
Page 293.
Page 293 in my lord's book, probably.
293 is appendix 9.
Yes. 9B, my lord.
9B of 9.
Yes, my lord.
Contractors associations.
One is Contractor Association, and within that, in that, my lord, two things. All divisions of PWD within the district, my lord.
Yes.
And concerned superintendent engineers. There's a reason for this, my lord. This is a policy decision by the government. This is approved by the cabinet, my lord.
No, but if it is circulated to others, is it illegal?
No.
Then-
My lord, it creates a problem where, my lord, what happens is that the small industries that are there, my lord, contractor associations, my lord, who have do these job works, my lord, which are essentially in the nature of repair, my lord. So they make available infrastructure, people, machinery there in the area, so that these works are given forthwith and they do it. And it's always
so that if given wide publicity, many takers may be there, for which they
will
will face
delay.
difficulty.
Yes, and will also substantially prejudice the small contractors, because this is up to 5 lakhs only.
See, just read the clause again.
Yes, brother.
It says notice inviting tenders
Yes.
for works costing more than 10,000.
Yes, brother.
But up to 5 lakhs.
Yes, brother.
Should be circulated
Among
local officers.
Yes.
Suppose if there is a requirement
My lord.
that it should be pasted
Yes, man.
in a particular office,
My lord.
then that does not mean that the notice shall not become viral. Even the persons throughout across the world may know about that notice. So this is regarding the employer's duty.
Yes, man.
To the extent to which
Yes.
the notice is required to be circulated.
Yes.
Whether this prohibits other contractors from outside the district or the area to participate or not is another question.
Yeah, that may be, my lord. Yes, I bow down to that. My lord, I'm only saying that the reason for this is that we are, as Contractors Association and members of the Contractors Association, my lord, we make available the infrastructure in that place. We are very small contractors. All these people are small contractors who do job work of this nature only, my lord. My lord, there will be so much prejudice that they will also, the government also will not have people in an emergency to do it. So that's the reason they've given that's the restriction, my lord.
There's no restriction.
Yes, my lord.
Where is the restriction?
No, my restriction means that it will be only circulated. Should
Okay,
be
that's
sent.
only. This is like must. It should be circulated here.
Yes.
Where is the restriction?
No, my lord. If it's not restricted, my lord, the difficulty is this, my lord. My lord, this is a policy decision that has been taken, my lord. When it was held, my lord.
Where is the policy decision? That must have reason.
This is the policy decision, my lord. This is the policy decision, my lord.
We don't know. That may be the purpose, what you are saying.
Yes, my lord.
But
restricted.
But this only means that it should be circulated among the local offices.
Yes, my lord.
It is not that the persons from that area only.
No, I may not be, my lord. But what happens by the order of this honorable court, my lord, past ex parte, a direction is given to a person who is not is an association of young entrepreneurs who are not contract association members, that they should be noticed also. That's my my grievance, my lord.
All right, where is the order?
Yes, my lord.
Annexure 1.
Annexure 1, my lord.
Page 17.
Page 17.
So item 39.
Starts at
Just a minute.
They have relied on a letter of the chief engineer, which now the state says.
No, my lord, chief engineer accepted my lord's order and acted upon it.
Yes, but in the counter, they say now that the chief engineer's letter on which this letter order is
Agreed with
based
all.
has been issued in by mistake or something like that.
Yes, yes, that is the plea of the state.
How can they say that when that is
I
already
don't
there?
know when that yet, my lord, has asked them.
Unless
No, my lord, I'm only saying.
You are referring to which order?
My lord?
Which order of the High Court?
Yes. The limited prayer in the present writ application that intimation regarding notices, my lord. Inviting tenders costing more than 10,000 and up to 5 lakhs should be sent to the petitioners, that is Orissa Young Enterprise Association, my lord.
Not a contractor.
And it is not a contractors association. It's an enterprise. They are the industrial association, my lord.
Page 56. Annexure 6, page 56.
No, but what we were saying, there is no restriction.
No, my lord.
We have given, there is no restriction and only contractors can participate anyway in the tender.
No, my lord, the 9B of the, I mean, the original place that you can only give, only a contractors association can
Where
tender.
is the word only?
Yes, my lord.
Yes.
Not in 9.2.
Then?
No, my lord, in the previous one.
Yes. Where is the word only? That is
yes.
what we are not finding.
Which is the one?
This one.
And contractors association.
These rules
bracket
will
S.
apply to all wings of the PWD under the administrative control of the government of Orissa in Works Department, Irrigation and Power, and so and so.
Where are you reading?
My lord, Appendix 8.
Page 280.
Page 280.
You have to tell us what you are reading. 280.
Yes. That is 280, my lord.
Yes.
These rules shall be known as PWD contractors registration rules. My lord, I have to be registered for the purpose of being given a notice and working. Like NTPC, everywhere it's there.
No. Charging.
My lord, may kindly take 2 of Appendix 8. One is registration. Next is no person shall be awarded any contract except within the permissible job limit.
See, we understand that. We understand that your submissions are twofold.
Yes, my lord.
One, that for award of contract, registration is mandatory.
Yes, my lord.
2, there is contractors association.
Yes, my lord.
So according to you, the members of the contractors association
alone
can be only those who are registered.
Yes.
This is your second submission. Your third submission is that 9B requires that notice would be circulated to the local offices and to the contractors association.
Yes.
So therefore, this court could not have directed for circulation to young entrepreneurs association. This is your
That's right. That's
or
it.
whatever
That's right.
association. This is your.
Yes.
How does that affect you?
My lord, no, my lord, it affects me, my lord, because of the fact that when you have to be registered, only if you are registered, you will be eligible to participate. If you are not registered, you cannot be in the zone of consideration. You cannot tender. So if you cannot tender, why should notice be issued to you? And that's the point. And my lord, there are hundreds and thousands of associations, my lord. Then it has to go everywhere.
It should be put in public domain. It's very easy.
Yes, public domain. It is put, my lord, if it is beyond 5 lakhs. It has to be. It has to be.
See. When was this introduced? 9AB was introduced when?
AB, my lord, they were, my lord, much earlier, my lord.
When?
This rule, my lord.
1991.
Yes, 91.
And when did you have your first laptop?
2015.
When did you get your first laptop?
I probably, I won't even know.
Computers,
So therefore, in 1991, we could not perceive, they could not have perceived that this can be put in public domain. And putting something in public domain or issuance of notice or publication of notice or circulation does not make someone entitled to participate in the process.
No, my lord. I am only no, my lord. And that is again further restricted.
No question of more public. The only question is that only such persons can participate who are
registered,
who are entitled, who are eligible. So that will not make the notice itself bad.
My lord, I am only saying the notice will go to a person who is registered contract I am not on that, my lord. If it is a tender more than 5 lakhs, it goes everywhere. It has to be e-tendering.
Yes, now you are right.
Yes.
The purpose of this limited notice is also for minimizing the cost of publication. It is not for the like if the work is up to 10,000.
Yes.
Why this paper publication should be done?
Exactly, madam.
Or 5 lakh. Why paper publication should be done? It should be circulated amongst the. So it does not mean that only local persons or they should be allowed to participate.
No. That the reason is, my lord, the reason is not far to see, my lord. What happens is that since it's an essential service, my lord, irrigation is an essential service. Water, timing of the rain and keeping the water available.
That can be seen at the time of award of contract.
No, my lord.
Award of work.
My lord, difficulty is this, my lord. What is happening? These people's difficulty is, my lord, once they are there, my lord, they are, it has been time immemorial that they are available. All these people, my lord, the small contractors, my lord, they're all available in these places, my lord, with their limited resources, my lord, having all the infrastructure for the purpose of this 5 lakh contract.
Your submission is, therefore, your submissions are contradictory. At one stage, you are saying that publication should be limited. And on the other hand, you are making submission that only locals should be allowed.
No, not locals, my lord. They have to be my lord, not local. The reason for the limited publication of the tender notice in the place, my lord, it's not mine, my direction, my lord, my decision, my lord. It is the courts. They have put that embargo on themselves, my lord, because of the necessity of the circumstances.
No.
And
necessity of circumstances is different. You have perceived the requirement of this notice as if this is only to encourage the local and small contractors to participate in the process. This is what you are saying.
Yeah, but my lord, ultimately is that, my lord. That is why it will be local and to the with the superengineer's office. That is the purpose, my lord, basic purpose. So that the small entrepreneurs who are there, my lord, they'll be benefited. Otherwise, the larger, anything beyond 5 lakhs, my lord, will be in public domain in e-auction, my lord.
And therefore, in the very beginning, I disclosed that, open my mind that, see, if a small notice is published
No.
in the, say, in the local office, one page, no, one short notice, that can be circulated throughout the world.
No, ma'am, it may be, my lord, can be circulated, it is fine, my lord. I am only saying the restriction is made by the government itself as a policy, my lord, to confine it to that superintendent's place or to the other place.
We are inclined to clarify it further, that it is permissible for them to put in public domain in the present era. You don't have to spend anything, not even a single pie. You just have to put on the website the notice.
Then, my lord, the government has to, I mean, the difficulty is, my lord, the marginal people will be destroyed for all times to come, my lord.
See, it is not that the government or these agencies are against the marginalized people. They also make plans. So it is not that it is, and how does it exclude you? It's not clear from this.
It doesn't exclude me. No. I am noticed, my lord. I am saying I am noticed, but I am saying that you cannot expand that scope of that thing.
Then you should say that these things should be kept confidential. Other persons should not know about it. Is this your submission?
No, my lord. I am only saying that contractors association who are members are the whole who are alone eligible to a notice, my lord. Because you have to be registered, otherwise you cannot get a notice.
Notice very difficult. Notice cannot be restricted, particularly in this era.
My lord, may kindly see. My lord, kindly see the 3, my lord. It will further clarify.
Yes.
Appendix 8.3. For the purposes of registration of contractors shall be classified on the following award. And the award of any work to individual contractors, the cost of exceeds amounts noted therein. Super class is unlimited. Then D class is up to 10 lakhs. The contractor shall be classified as follows for award of the work. My lord, if the person cannot be award, my lord, a person has to be A, my lord. My submission is that A, they have to be registered contractors association. 1, A. B, my lord, they have to have a category. You have to have a license for it.
Why are you mingling these two things, notice and award of contract?
My lord, if I don't, my lord, what is happening in the process, my lord? There are none of the work is being done. The difficulty of the government is, my lord, none of the works are being awarded.
Take care of that.
Awarded.
The government will take care of.
They are not, my lord. Nothing is happening. Let them say.
Nothing is happening, then they will do. How can you? All right. What is your relief in this region?
My relief is, my lord, this is passed ex parte without notice to me. I am a member of the Contracts Association. I was a necessary party to it. And I am saying that this is a decision which is a policy decision, whom to give notice and who are the people who are entitled to be eligible for the zone of consideration. Only they should be given notice. And within that comes a person who has been registered as a contractor under the OPWD code. If they are not registered Contractors Association, they cannot have a right to even tender. If they don't have a right to tender, my lord, no, there is no question of giving them a notice. That is my submission, my lord. That's my submission. 3 also, my lord. 3 says, my lord, there are categories, my lord. 3 gives categories, my lord.
Yes.
3 of Appendix 8 gives categories, my lord. To which level a registered contractor can tender, my lord. Super class is unlimited, my lord, whatever be the value.
Yes.
He can be in the zone of consideration. Special class is up to not exceeding 8 crores. A class is 33 crores. B class is 100 crores, 1 crore. C class is 20 lakhs. D class is not exceeding 10 lakhs.
Yes.
So these are the people who are registered contractors in the D class, my lord.
Yes, we will see, Mr.
And my lord, my lord, may kindly see. There's an amendment in 2007. That is I'll just show that page, my lord. 8. Appendix 8 to the consider.
Yes.
Appendix. In 2007, there's an amendment, my lord.
Yes.
After careful consideration of the government have been pleased
Where are
to
we?
decide. That, my lord, I have to find out from my lord's what is before my lord. I am on. Yes. Yes. This is written, my lord, amendment 2007, my lord, of appendix 8. Clause, my lord, is not indicated. It is dated 2/8/2007.
Yes.
I have that one in my book, my lord. The amendment is here, my lord. In this book, this is a cop. That is the shorter version of that, my lord. Which
So what does that say?
That says, my lord, after careful consideration, the government have been pleased to decide that bidders registered under other state government railway seatware equivalent rank may participate in a tender in the work of the state, but successful bidder has to register under the state PWD code before signing the agreement. Yes, I'm not on that against one, but I cannot. They cannot go ahead. I mean, everywhere, if anyone, my lord, there are few thousand associations, my lord, in Odisha. There are young entrepreneurs association. There are small industry association. Everyone. So every one of them will come and say that you have to be given notice. That is obviously not the purpose of the CPWD code. The restrictiveness of the OPWD code is for that purpose.
The restrictiveness is for a different purpose. Like if you have to, just for example, I'm giving this illustration that if a person, someone is to be engaged on contractual basis.
Yes, sir.
For 3 months. And if there is a provision that in such case, notice can be pasted in the administrative office of a particular department. That does not mean that permits the employer to limit the area of advertisement, the area of notice. For that purpose only. So anyone can participate.
No, my lord. You have to be a registered contractor to participate.
That we understand. That is eligibility condition.
Yes.
But
if the eligibility condition is not there, my lord, why should there be, my lord, to that association? My lord, I'm only saying Young Entrepreneurs Association. There are 20 or 300 associations like that, my lord. So if the judgment of this honorable court was to be held to be right, my lord, every one of them have to be given. Every one of them, my lord, they say that contract we should be given. They're saying that not given the portal, they have to be given themselves.
No, we can allow them to do it. Instead of circulation, we can ask them that put that on portal also.
Yes, my lord,
that can be done.
Email service also.
That we can clarify.
Not email, on the website.
On the website.
Only website.
Anyone can have. So why only one?
Why one? Why not everyone? It should go then.
Yes, my lord. May I just pray, my lord, one thing? This very petitioner has filed another writ application with the prayer that calling upon the opposite party to show cause why the appropriate writ of nature of secretary may not be issued or direction shall not be issued, the NIT only to those contractor or contractor associations who are registered under the PW.
Yes.
The very same prayer he has made in a writ application filed in 2023, that is bearing number 22160. That is dismissed, the very same petition. Then he filed a review application that is also dismissed. And in the present writ application, it has not been mentioned.
What is that?
The WPC number 22160 of 2023. And review application number
WPC 22160 of
2023. Disposed upon 21 July 2023.
What is the order of this?
21 July 23.
Yes, madam. I have the order. Very. One copy of.
And
And then there is a review application. That was also disposed of, rejecting their contention.
dismiss it.
So the nature of the prayer is same, only the wording has been different. Here, they want to recall that order passed in the WPC.
It seems, my
And,
lord,
and the second, my lord, this is pursuant to the government direction dated 25th June 2020. That also annexed here. So that's the government direction that for these kinds of mechanical work, the notice should be PWD code is made applicable.
Yes.
And that is not challenged.
It's never paid. You have to go to the main. It's all right. Notice it. Also. Oh, yes, yes.
One 160.
My lord, I stand corrected this.
Not to the associations who are not registered. The read petition I'm heard. But I have the I have the copy of the read application, my lord. Well, that order.
Where is the review order?
That has been dismissed on the ground that the order has already been passed, my lord, for the purpose of giving them. So therefore, my lord, obviously it had to be dismissed because my lord Justice B.R. Solanki also was a member in that matter. In few of the writ applications. Started, my lord, with one judgment of order of my lord Justice Murli as he then was. And thereafter, your ladyship with S.K. Mishra. Then thereafter by B.R. Solanki. My lord, it was what was hitting them was that order, ex parte order that was passed. Basing upon that, everything else happened. So I had to come in a writ application, my lord, and I was not a party there, my lord.
That repetition which you have filed that has been disposed of, saying it is not.
See, there are 2-3 questions. We will decide whether you are necessary party or not.
Yes.
These points we have taken a note of, we will consider, we will decide.
And my lord, whether an ex parte order of this nature could have been passed.
Whether the order is ex parte or not, that is the question.
Yes. No, it is.
Sir, you are not going to write a judgment.
No.
Whether you are a necessary party, we will hold that. Whether you are a necessary party or not.
Yes.
You are a necessary party, question of ex parte arises. If you are not, then no question.
Yes. Where is the review order?
Yes, my lord. The review order dated 15th March 2024.
15th March.
Review petition number 387 of 2023.
What for the review application was filed, madam?
Where are the orders?
The certificate, it has never been mentioned, and the entire that 9B and other things.
Yeah.
Yes, madam. There is another person coming this with the same prayer, and coincidentally my lord, yes, my learned was also appearing in that matter. Lakshmi Dhara Bhuya, that's 14423 of 2023. Yes, my lord.
Yes.
That is also mentioned in this application.
My lord, I bow down that my learned friend, we should have indicated these applications this
We will
morning.
see.
That, my lord, we haven't. I agree that we haven't, because we challenge essentially the order that was passed ex parte, and we feel ex parte, and it was expanding the scope of the PWD code
We will consider.
for that purpose.
And the government circular is at page 42, that is 25th June 2020. Basing on which this order has been passed, if your lordship page 17 of the present application, your lordship, it is seen an amendment to clause 9A and B of appendix volume 2 of the OPWD code, as well as in the guideline and instruction dated 20th July 2019, 20th March 2020, 31st August 2020, and 25th June 2020, intimated regarding the NIT are present. So that is all our government decisions taken that this is to be circulated, and the PWD code will be made applicable for the nature of the work. That is also annexed, and that is not challenged. That, and the REIT application has filed that these instructions which have been passed by the government is not followed. Therefore, they were not required to be made party, because we are not saying anything. That is what is there as per the government decision. We before your lordship that they are not following in letter and spirit.
Yes.
And even that as a history, this honorable court in another REIT application headed by my Lord Justice is Miss I.S. Ponda, as his citizen was. There also the same thing was noted down. You have to follow that 25th June 2020 notification.
Yeah.
That is REIT petition number 8176 of 2021. In that REIT, my lord, the order of which has been asked to be revised, there we have annexed one order of this honorable court passed in WPC various REIT application. One of them is leading 18379 of 2020 and order dated 12th October 2020. There it is a categorically direction that you have to follow the guideline prescribed under 25th June 2020. In spite of these directions and the notification, since they have not followed, we came back before your lordship seeking mandamus. That order in the second REIT. My lord.
Whether Contractors Association has been defined anywhere?
No, my lord.
Defined, my lord.
Huh?
Defined, yes.
And there are wide participation.
No, they must be private. My lord, what I'll do, my lord, may I be permitted to file a short note?
No, not required. You may do.
Oh, no, only for the purpose of these small nitty-gritties.
All right.
I'll file a 2-pager. Only for the purpose of indicating all that.
No, Contractors Association, whether that has been decided,
Yes.
defined or not.
What throws light, my lord, is on that page, that what are the people Contractors Association?
Strangely, my lord, the executive engineer said the chief engineer has committed the mistake in the counter. And this-
Executive engineer has filed an affidavit
saying that chief engineer has committed it.
Yes, and they have filed a response, my lord. State has filed a response. State has said that a mistake has been made because the parent department was not asked.
So what is the meaning of Contractors Association?
Contractors Association is that one who is registered under this.
How do you say?
My lord,
Contractors Association means what? Where has that been? Is there any recognition of the Contractors Association?
yes, my lord, this is contract CPWD code. I have to.
Please, whether there is any definition of Contractors Association in the OPWD code or not.
I'll have to look at that one.
Because contractors are registered, that is
So
there.
even 10 persons, 10 registered contractors can join and form an association. That is also Contractors Association.
Yes, my lord, provided you are a contractor association who is registered as CPWD.
Therefore,
my lord.
Therefore, we are saying that if there are 100 registered contractors,
Yes, my lord.
there can be 10 contractors associations.
My lord.
There can be 10 registered contractors association with 10 registered contractors each.
Possible, man. That's possible.
therefore, that association which has been referred to in this order, they also may be registered. We don't know.
This, my lord, is OEA is not registered, my lord. It's not a contractors association. It's a small industry. My lord,
Provide that the association has to be registered under the code.
my lord, you have to first be a contractor, my lord. Yes.
All right, all right. Have you stated anywhere that members of the OYEA
are
not registered?
Yes.
You have
we
stated?
Yes, ma'am.
All right.
We have stated that.
We will see.
We have stated.
We will see.
That's what I'm saying, my lord. So if he is not eligible to participate, why should he be given a notice?
All right.
That is all I'm saying.
All right.
Page 15.
Many of the.
My lord, may kindly see page Annex 6, my lord.
All right.
Annex 6, my lord, may kindly see.
What?
It is their registration certificate.
Sir, have you stated anywhere in your writ petition
Yes.
that members of the association are not registered contractors?
No. Yes,
Sure.
my lord. That
So where
yes.
is that statement?
Yes. That is the only point that we have, in fact, canvassed. OEA is not a contractor association. That is the CP2. That is you must have made the first amendment. Paragraph 2.8.
Page 7.
Page 7. That the Orissa Young Enterprises Association, which is an association of shopkeepers, service enterprises, and many relevant SSI units are not contractors association as per Rule 1967 of the Orissa government to have rejected OEA's request for circulation of NIT to them, instead directed compliance of 9B, which stipulates that the NIT only to the contractors association can be only sent to the contractors association.
Then we have not been able to convey properly the question which we wanted to put. Sorry. Karo. Judgment fixed. Yes. 2 weeks. Judgment. Heard. Yes, next.
So, same issue is involved in both the
Both.
applications.
Yes, yes, yes. And Manoj, give me time till Monday. I'll file a short synopsis. I'll give the whatever my lord, what is fallen from my lord, I'll give that.
For admission item number 30.
Reasons matter. On the last occasion, Lordship directed me to obtain instruction as to whether the NIC has responded to our letter or not, that the IG presents letter. My lord, I have obtained instruction. Today only I have been served. Kindly. Instruction that NIC has responded, in fact, yesterday only, convening a meeting, directing the last para, they have mentioned, email we have received on 12/11/2024, Mr. Malay Kumar Das has requested the prison directed by email to convene a meeting with DG of prisons to discuss the scope of application to be developed. A copy of this email as well as the director letter so and so are enclosed for ready reference. They have requested that the meeting be convened so and so. Say they want that meeting should be held and they will develop that module for training, etc. My lord. As per your lordship's direction. Your Lordship's order.
And what kind of association do you have? Does the state have with the NIC? If the NIC is not, if the NIC does not respond, then you will stop working. The government policy, the government plans are dependent on NIC.
NIC is the competent organization which can develop that because it's a technically. I have to obtain instruction. If any other organization is there, I have to obtain instruction. I have any other organization we can sort for the assistance or involvement. Because then OCAC is also there. So we can also seek for the assistance of the OCAC.
They are unwilling. The department is not willing. They could have said that we will not do it.
But they have stated that
you are unable. See, we know our own limitations. We cannot run your department. If you are expressing just your inability to have opinion from the NIC.
NIC in fact has agreed to sit for a meeting and for discussion, my lord.
You are saying that they are doing nothing.
No. Last paragraph of this.
Despite several requests and persuasions, has not yet given any estimate feasibility for development.
Next para. On 12/11/2004, Mr. Madhav Kumar Das, yesterday only, has requested the director by email to convene a meeting with DG of Prisons to discuss the scope of application to be developed. Copy of. So in fact,
they will again not respond.
My lord.
The NIC will again not respond.
NIC is writing this letter to us. NIC is writing to letter. The senior scientist is the NIC person, my lord, IT. Madhav Kumar Das is the NIC official.
Oh, he is from NIC.
NIC. Senior scientist, HOD, state, NIC has requested. Are enclosed for kind of.
So this of 7/10/2024.
Yes.
On 14 November. All right. Tomorrow, huh? On 14 November.
Yes, they want that meeting should be held on 14 November.
It was 14 November. We convene on 14 November. Next page. No, that first second page.
Meeting meeting to be convened 14th November. Lordship may direct both of them to convene the meeting tomorrow and what decision to be. Because they have agreed, they may defer another clause is there or any suitable date. They should not adhere to that. They should.
So tell us tomorrow. In the afternoon at 4.
Monday. Your lordship may call it Monday. We'll apprise what development have.
No, tomorrow.
Tomorrow, because tomorrow is the 14th. They will convene the meeting tomorrow.
You may tell us tomorrow that the meeting has been convened, has not been convened, whatever.
After this,
all right. We can take up this matter every day.
Anytime, your lordship, please. Because
every day.
Will be conveyed tomorrow, my lord.
5 minutes, 10 minutes.
Day after tomorrow, my lord.
May I say something? My brother is appearing that your lordship directed tomorrow to inform. So the outcome of the meeting, he may be in a position to inform.
No outcome. There will be an outcome of the meeting if meeting takes place.
Yes, ma'am.
So if any meeting takes place, then there will surely some outcome. So outcome we will see, what is the outcome on Monday or Tuesday, whenever, but
Yes.
tomorrow we would
Yes,
like to know
tomorrow we are going to
you-
hold
how serious you are about
tomorrow we are going to hold the meeting, my lord, and we will,
hold it, we will see.
yes, we will apprise all lordships on Monday. 18th.
Not Monday, tomorrow,
Tomorrow, after recess, my lord.
after recess.
Yes.
Mr. Mishra, what we want, that there are so many orders. And we wanted some kind of classification, like nature of orders, what are the main issues which we have taken up. And then issue-wise, what are the main issues which we should take up, which can proceed in a planned way, better planned way.
In fact, the understanding with the government is that in terms of order number 65, wherein all the points have been highlighted, if they put that in a systematic portal, then major
That will solve.
daily issues.
Yes, let us post this first.
Yes, so if that is resolved, then a major chunk of the work of the DLSs, of the government, of the prisons, the home department, all of them get resolved.
And your state will be the first in the country if you do it.
Yes, yes.
It will help them actually.
And it will help everyone.
It would be centralized for them.
My lord. No, 65, I am just looking. 65 is an exhaustive order, my lord. 65 is the,
Which
is the
in principle they have
guiding.
agreed, but it has to be just pushed so that they come up with something concrete.
So we are taking note of your this communication.
Yes.
And we are posting the matter tomorrow.
At 2 p.m. Lord.
And we may take up this matter every day. All right. Sometimes in the presence of any departmental secretary, sometimes in their absence, sometimes. No, you may.
No, I'll be happy to assist.
Then it may not be possible.
In fact, there was one more small issue with regard to the registry. The Lordship had called for an explanation. I just wanted to draw that
what
something.
happened?
The direction is at para 2 of order number 67. And the explanation is at flag 188 onwards. That was regarding this non-filing of some affidavit. There was some delay in putting it up. 188, 189 and 90, the three explanations are in terms of my lord's order. Order number 67, dated 6th of November 2024. If your lordship may recollect, there was an issue regarding that affidavit not coming on record. For that, lordship was prompted.
I don't know the system, I can't say. Comment. We have seen the explanation. No, no, see the explanation. Explanations submitted by the officials of the registry, comma, in light of this court's observations in the order dated 67th.
Order number 67.
67th order.
Order for the file should have been sent to the victim. You're saying file was not sent. Who should have sent to the file? It was not gone to the taking assistant. That is the explanation. On 30th, the order was passed. The file is the taking assistant on 8/11. The matter was listed on 6/11. That order was there with a slip, we could have sent.
By the registry. First off, we are not satisfied with the failure on the part of the registry to place a digital copy of the affidavit on record as directed by this court on 30th we are directed 30/10/2024. When was that directed?
The order is. 6/11. They say.
Also. Let the Registrar General put an exhaustive note treating this aspect as an illustrative case. Treating this event is illustrative in nature with concrete suggestions, on this administrative side before the Chief Justice. Yes. उसको आगे देखो। Learn. नहीं, no, we'll sort it. I know how we have to sort. This is the- and AGA has produced before us communication dated 12/11/2024 addressed to him by the Director of Prisons, by DIG of Prisons, Headquarters Bhubaneswar, from which it transpires that an official of the NIC has requested the Directorate of Prisons and Correctional Services, Odisha, to convene a meeting with DG of prisons to discuss the scope of applications to be developed in the light of this court's observations made in the order dated 26/9/2024 passed in this case. Full stop. From the said letter, it appears that the meeting that the NIC has requested to convene the meeting on 14th November or any suitable date for full stop. List this case on tomorrow to be taken up at 2 p.m. for learned AGA to inform as to whether the meeting has taken place or not. That's it. Tomorrow. And in the meanwhile, please, you can, the orders, there are so many.
Which is help you. The reports can be placed in one folder so that 6 pages of the cause list is not.
My lord, in fact, I'll discuss with my lord Courtmaster and try to resolve this.
Yeah.
Earlier, I had also requested.
You will get all the entire order sheet.
My lord.
Entire order sheet.
Order sheet has been uploaded. All orders are uploaded in this. In fact, the High Court website has a portal where important PILs, all these reports are also uploaded. So this needn't be in this bulky file needn't be there. And some of them have lost their relevance. So this can be easily streamlined. It's not a difficult thing.
Mention in the cause list that can be.
That can be easily done. I'll have a discussion with my lord Courtmaster and get this done. Last 5 to 6 orders only would be relevant, because what we have been doing is giving a updated note for every day. So it can be easily.
Letter.
Item 31.
May I plead lordship? I'm appearing on behalf of the opposite parties here. The petitioner had filed this present petition for because his name was not enlisted in the list of bidders that was provided in the notice of the OTDC, the opposite parties. Lordship, it is for the for new elevators needed at Puri Panthanivas. And why our letter dated?
This petition was filed in 2018.
2020, Milots. Just me let appraise your lordship. I am for the petitioner, Milots. What has transpired, Milots, from this case is that there was a tender being made for installation of lifts, elevators in a Panthanivas Puri, whereas it was a tailor-made tender. What I say mean to say that they made some specific. Only those companies can.
Do you know DOSA?
Milots. Why?
Decision-oriented systematic analysis. That is, DOSA means decision-oriented systematic analysis. So you put such conditions in the NIT that a particular person will get selected. That is the expression which has been used in one of the Supreme Court's decisions. Yes. So
that's what has happened. There has been only 4 companies which have been tailored made that these only specific companies can take participation. So
that they can do.
Milots, my challenge is that when I have the credentials, the eligibility criteria, I fulfill all of the eligibility criteria. if they do it in a public domain, whether they should have done it by an allocation. If they want to make a specific, they can do it by an allocation. Why to make a tender? If they are making a tender in public domain, they should allow all the companies to.
All right, let us see what was the condition.
Milots, before that, Milots, what I have received a memo from
2020, we are in 2024.
No, Milots, what I have received a memo from my learned friend Milots. This memo reflects that they are willing to cancel the tender. They haven't, but they are willing to. This is the memo that I have received today itself. Milots.
Yes, so this will become, and even then, even otherwise it
Milots,
is.
what my humble prayer will be that let them first cancel it. Your lordship may pass a direction to cancel it because they haven't cancelled it yet. It's in pre.
All right. We will give you liberty to revive the writ application.
Milots,
If they proceed.
Milots, may I suggest something, Milots? Let them cancel it. Let the pre-petition lie. Let them cancel it. It can be infructuous.
No purpose.
As your lordship pleases. As your lordship pleases.
Let them not cancel the
As your lordship pleases.
Petitioner has filed the present writ application. Questioning the NIT. Questioning NIT bearing identification number PIT. Bid identification number BP 1/22/2019 -20 dated 12/12/2019 for supply, installation, testing and commissioning of 6 passenger elevators and dismantling of existing lifts at Panthanivas, Puri. Stop. It is the petitioner's case that its name has been intentionally omitted from the list of permitted bidders. This is your case?
Milots.
Next. It is the petitioner's case that by specifying the make of the elevators,
Elevators,
the very purpose of e-tendering stands defeated. From next B, we have heard so and so. This memo is on whose behalf?
On behalf of opposite parties.
On behalf of the opposite party, on behalf of Orissa Tourism Development Corporation, Mr. Shalja Nandan Das, learned advocate, has filed a memo based on communication made by the Orissa Development OTDC that a decision has been taken to cancel the existing tender and float a new tender. So stop. Next. In such view of the matter, in view of the stand which has been taken by Mr. Sailajanandan Das in his memo, comma, which has been taken on record, comma, this application stands disposed of as having become infructuous. So, learned counsel appearing on behalf of the petitioner has raised apprehension that the opposite parties may not cancel the NIT, may not cancel the tender process and may continue with the same. So we make it clear that if that happens, then counsel for the petitioner shall be at liberty to apply for a revival of the present proceeding. Yes.
Third line in that letter which you have read.
Is it?
First paragraph.
Yes.
Yes.
I'm sorry. The company secretary. I'm sorry.
Item 32.
Milots, just one more humble prayer, Milots. What I wanted to say, the whole procedure or the whole idea of filing this writ petition, the motive behind filing of this writ petition was to make it in a public tender, Milots. My only humble submission that if a fresh writ tender is being floated, this particular clause should be taken care of. That is my only.
That is why we have noted your submitters while disposing of the writ application.
No anticipatory direction.
It will be just argument.
Before
Yes.
some will not scan.
Grateful.
Item 32.
Item 32, I may be permitted to place the matter on VC. Actually, in the first three matters, Mr. Rath has been, my learned senior, Mr. Rath has been instructed to appear on behalf of the petitioner. Lordship, I'm just seeking 2 weeks adjournment for the same.
In this item 32, in the first matter, I have filed an IA. That is at flag Q. Because on my mention, this matter was listed last occasion, I have directed to list all these matters for final disposal. Now the lawyer has been, senior counsel has been engaged.
You are for whom?
I am for the OP number 7.
Is there any interim order?
Well, because the pendency of the writ petition and instruction issued by the earlier government counsel, Tahsildar is not proceeding further in the matter.
So what is the matter about?
Well, the matter relates to settlement of Sand Swarat source.
So we can observe that pendency of the writ petition will not come in way of.
Yes.
That we can do.
Yes.
Lordship may kindly see the last order 5/11/2004, wherein your Lordship observed the IN number 10188/2024. If the application has been filed by opposite partner 7 within the following prayer, in the facts and circumstances stated above, it is humbly prayed that this honorable court may be graciously pleased to clarify, modify order dated so and so, passed in IN number so and so, extent there is no prohibition in the order dated so and so, and your Lordship wanted that desired, then let a copy of this application is served so as to ensure on behalf of the opposite party whether this so as to enable him to obtain instruction in this matter, because they want is relief claimed here, being an intervener, my lord. They will in whether form number F, whether form number F in favor of the intervener petition as per rule 27(9) of the OMC rule 2016 by the OP number 5 Tahsildar Askar during the pendency of the accompaniment, that your Lordship is going to pass the order, my lord. But in fact, the intervening intervener, he cannot claim any relief in a writ petition filed by the petitioner.
I am the
the garb of your Lordship's observation.
Any interim order?
He is seeking an interim order. Lord, there is no interim order. Under the garb of your lordship's observation, they are trying to say, take some interim order. But I only request your lordship, let it matter be taken up even tomorrow or Monday. I am ready.
No, we will take up. Otherwise, if because of the pendency of the writ application.
No, Lord, there is nothing. There is no evidence before my lord that during because of the pendency, they are not proceeding. State is not taking such a stand. They are trying to take an interim order from my lords.
Keep it to tomorrow, it can be disposed of. Tomorrow, my lord, will keep
On
it.
Yes.
On merit, it can be disposed of, my lord, but no interim order because intervener cannot. No, he is claiming now he is claiming that one clarification that they are seeking. In the garb of clarification, they will take advantage of, my lord.
See,
yes,
if there is something in his favor, just we are giving you an example. If there is something in his favor, and he is not getting that because of the pendency of the writ petition, he has every right to tell the court.
To seek early disposal, my lord, of the writ petition.
Huh?
Expeditious disposal, early disposal. No, dictate no.
But I can do it
that
tomorrow.
Is the law,
Let it
law
do
laid down by your lordship, my lord. That is
Tomorrow,
the
it can be
I am
disposed
only.
of, my lord, keep it.
I am.
In my case, my lord, in the last item, I am the highest bidder. I have deposited the entire amount since 2021, but I am not getting, my lord, leads.
Why?
Due to my pendency of this.
Pendency of the writ petition, then what are you doing? What is this? Because pendency of the writ petition, they are not doing anything and you are not, and the writ petition is pending for last 3 years.
But in my tomorrow, one letter was issued from the Advocate General Office to stop execution of lease deed. Though there is no interim order.
All right.
You are happy with that?
Since 2021, I have
Happy with that because you are not getting the matter listed.
I will do it tomorrow. Tomorrow I can do it.
My deed application, lordship can see.
Let it come to all these matters come tomorrow, can be disposed.
As requested on behalf of the petitioner, list this matter tomorrow.
Last occasion, my lord directed to list all these matters within top 10 matters. Now it has gone out.
May I primal, small primals?
Directed within top 5 so that can.
A small primals. I'm so far item number 1. Sub item number 1. I'm for opposite part number 6. Has to be done. May primal can be taken up Monday, my lords. Because tomorrow. Right, that's my. I don't have it because I understand that. Tomorrow I may not be available because of my health checkup. That is what I requested.
You are petitioner.
No, I'm for the opposite part number 6. The highest bidder. If the petitioner loses, then I am to get it, not opposite part number 7. What opposite part number 7 converses here, my lord,
to be decided here, my lord. My lord, whether the petitioner will end.
Counsel, your colleague is not well. He is going for medical checkup.
No. So far as the relief,
I humbly request all of my friends, my lords.
Monday.
Monday I am not there. Tuesday. 19th.
Tuesday. All right.
Tuesday. Within top 5.
Maybe at 2 p.m.
2 p.m. 2 p.m. Yeah.
2
Yes, ma'am.
On that day. On that day.
2 p.m.
About 34.
This case, your lordship has already given time on 29/10/24 file the substitution. Substitution is ready, the officer has not come in. By Monday, I will file it. For affidavit, there is nothing.
List this matter on next Wednesday, as requested by learned AGA. Learned GA. Representing these appellants. Yes.
Item not 36.
In item 36, I am for the appellant, my lord. Mr. Das has appeared for the respondent. 36.
Where is Mr. Das?
Mr. Das, vote number 25, may I pray for next week?
Oh, what is this matter about?
This is regarding my.
But it's praying for time on
No, my lord, what has happened?
He must be sure that you are going to lose.
He
No,
requested.
no, he must be sure that you are going to lose.
No, my lord, Mr. Das requested me, so I.
tomorrow, Monday.
Item 37.
Item 37, I am appearing for the appellant, Your Lordship. On the last occasion, Your Lordship had directed the governing bodies council with the college council to obtain instruction whether the governing body has been constituted or not. In this, and even the state was also. Yes, Your Lordship. The Aeronautics Society.
Our stand all along is opposite party number 3 is not the right person to constitute the governing body. That is our stand from the beginning. Party number 3 is an agency. Opposite party number, opposite party number 3 issued the suspension orders, also draw and charge sheet. Those were challenged by the petitioner. So since our stand was opposite party number 3 doesn't have that jurisdiction of suspending and he doesn't have any power. So we submitted before the honorable single judge that if he didn't have power to suspend or to initiate a proceeding, then how come that very same authority promoted the petitioner to the post of senior lecturer, thereafter to the post of reader? That is.
It is, and when Your Lordship, if Your Lordship peruses the promotion order, it is not me who has only been promoted.
No.
Along with me, others are being promoted.
We can permit you to withdraw the writ petition.
That is.
As you wish.
Permit you to withdraw the writ petition.
The single judge. That also.
That means.
That only allows me to get few extend like more subsistence allowance, nothing else. Because now I'm the issue is, Your Lordship, even if it in the single judge in the order itself, the impugned order itself had directed to constitute the governing body within 3 months. And the 3 months period has already been lapsed, Your Lordship.
Abide by the order. That's fine. Withdraw this writ appeal then.
No, even if we consider the order of the single had directed for 3 months to constitute the governing body. And till date, they have not even obtained
Mr. Counsel, you were put under suspension.
Yes.
That suspension order has been interfered with on the ground that the person who passed the order did not have the jurisdiction.
Lordship.
And with the same logic, your promotion has been held to be.
Lordship.
Just decide whether you want suspension or promotion. You are representing whom?
I am for opposite party number 3. No, sorry. Respondent number 3.
If we, you can seek instructions also. You withdraw the writ petition, then we can.
Lordship, give us 1 week time. I will seek that instruction. It's a very peculiar circumstance I have in.
As requested by
Mahanti.
Mr. Mahanti, Land Council, list this matter on 1 week so as to enable him to seek further instructions. Appellant for the petition.
Item number 40.
Last order to punish the status of opposite party number 3 that you filed the affidavit. Item 37.
Yes. Chetan?
40.
40.
May it please your lordship. That's the petitioner was participant in a tender that was floated by the opposite parties. And on opening of the technical bid, he was qualified for opening of his.
So we had heard you, Mr.
Sorry, madam.
Is this the matter you were mentioning yesterday, that
Yes.
innocuous order may be passed?
Yes, I'm sorry about that word innocuous. I'm sorry about, but since this particular bench has passed an order that any tender in the meanwhile will be subject to the outcome of the writ application. So I thought that since your lordships were not put,
First date or second date? This is, I think, counter is there on record.
pleadings are on, and Milords, it's covered by a series of judgments of your lordships. They've dealt with each and every aspect. I had participated in the tender. I qualified technically. My financial bid along with the other participants were open. I was declared L1. And then I was called for verification of documents. And I went and participated in the verification of documents which were found to be in order. Then the tender committee recommended my tender for approval to the competent authorities. Now, behind my back, without informing me anything, the tender was abruptly cancelled. This is what has been deprecated by this honorable court in a series of judgments, some of which have been upheld by the apex court, as have been marked by your lordships, Milords. Milords, just with your lordship's permission, I have got 7 judgments of this honorable court. I'll not go through the entire judgments, just those operating portions and the point of law involved. I have got copies for both of your lordships, Milords.
Once they declared L1, they cannot cancel the tender.
They can, but not behind my back without giving an opportunity of hearing me. And this honorable court has also held, well, there is no fault on the part of the tenderer, the tender cannot be cancelled. Milords, this is, I'll just read the footnote. Cancellation of fresh
No, please
invitation
don't
for
read
bid.
footnote.
Read by 3.
Please don't read footnote.
Sorry,
Or
Milords.
anything.
Sorry, Milords.
Please don't read that. If you are reading Placitum, please don't do.
Okay, I'll come to the portion, Milords. Lordship may kindly come to para 3. Para 3. Lordship got it?
Yes.
Mr. G. Satpathy, learned counsel for the petitioner, urged that the order impugned in Annexure 4 cannot sustain in the eye of law, as no opportunity of hearing has been given to the petitioner before such cancellation. The petitioner having been found suitable both in the technical bid and financial bid, cancellation of the tender pursuant to the impugned order in Annexure 4 without complying with due provisions of law cannot sustain, and accordingly he seeks for quashing of the same. Para 4. Mr. P.K. Mudali, learned additional government advocate for the state, referring to the counter affidavit, strenuously urged that the petitioner was found responsive as per technical evaluation, which was uploaded on 14/1/2016, and financial bid was opened and the summary sheet was uploaded on 15/1/2016. And on detailed verification of the bid documents of the petitioner, it was observed that the work credential of Sri Saroj Kumar Sharma, the so-called 4th partner of the firm, was not in order in view of the affidavit dated 24/9/2011, along with the clarification of Law Department dated 11/3/2002. Therefore, the bid of the petitioner could not be considered as responsive, and hence the tender was cancelled on 5/2/16. Thereby, the authorities have not committed any illegalities or irregularities in cancelling the tender in Annexure 4, which does not warrant interference by this court at this stage. To substantiate his contention, he has relied upon the judgments reported in so and so. Now, para 5. Pleadings have been exchanged by the parties. The matter was heard with the consent of the learned counsel for the parties. Para 6 is important. Having heard the learned counsel for the parties, and after having going through the records, it appears that the facts narrated above are not in dispute. On perusal of the impugned order in Annexure 4, dated 5/2/16, it appears that by a cryptic order without assigning any reason, the tender has been cancelled, and more so, it appears that the said cancellation has not been communicated to the petitioner, which is also my case. It is admitted the fact that the petitioner has qualified in both the technical and financial bid pursuant to the invitation bid in Annexure 1. But in order to justify the action of the authorities, the tender reasons have been assigned in paragraph 5 of the counter affidavit, which reads as follows. Your lordships have deprecated that you cannot supplement your actions by filing counter affidavit and submitting reasons thereof. Now, my lords, para 7. In the counter affidavit, the reasons have been assigned which are not available in the impugned order of cancellation filed before this court in Annexure 4 dated 5/2/2016. More so, while cancelling the tender, the principles of natural justice have not been complied with. It is well settled principle of law laid down by the apex court in Mohinder Singh Gill and another, the Chief Election Commissioner, New Delhi, and others, AR so and so. Now, Para 8, it relates to public orders passed by the Honorable Supreme Court. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the acting and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Orders are not like old wine becoming better as they grow older. Para 9, in view of the law laid down by the apex court mentioned supra and looking at the impugned order in Annexure 4, conclusion can be drawn by a cryptic order the cancellation of tender has been made, which has been explained by filing subsequent affidavit. The same is not permissible under law. And it was quashed. The cancellation order was quashed. Now the second judgment, Milords, it says,
Cancelled because non-availability of encumbrance free land for the total length of 4-lane work of the road.
That is not the reason that has been given in the order of cancellation. That has never been communicated to me. That has been done behind my back, Milords.
That is based
I
on
have
the
not been
letter
heard.
of the special. You have to be heard.
I have not been heard.
All right.
And Milords, the second judgment which I am just handed over, Lordships have held Para 7. A tenderer cannot be allowed to suffer. Para 7, Milords.
Yeah.
Because of the fault and inaction of the opposite parties. In the present case, it is clear that the opposite party sat over the matter and allowed 90 days to expire. In my case, it is 120 days. Without there being any fault of the tenderer, and then for cancellation of the tender call notice, gave the reason that 90 days period has expired. If this is permitted, that in every case, after opening of the tender, where the lowest bidder does not suit the opposite party, they can always sleep over the matter without taking any decision and resorting to clause 17 of the detailed tender call notice, cancel the notice itself, which in our opinion cannot be justified.
Yes.
Had there been any fault on the part of the petitioner, the case would have been different. In the present case, the opposite parties have not stated anywhere that either the conditions stipulated were not fulfilled by the petitioner or that his tender was not the lowest. As such, not awarding the work to the petitioner in terms of the tender call notice cannot be justified in law. And Milords, Para 15. Para 15.
Yes, sir.
In view of the aforesaid, this writ petition deserves to be allowed and is accordingly allowed. The orders dated 4/2/2016 and 3/2/2016 are quashed only to the extent with regard to the work at serial number 1 and 2. I am on serial number 12 of the work, which is at page 9.
Yes.
The petitioner would thus be entitled to be awarded the contract with regard to the works at serial numbers 1 and 2 of the said tender notice call notice in accordance with the terms of the tender call notice, which should be complied with within 6 weeks from today.
Yes.
No order as to cost. Now, in every subsequent judgment, Milords, your Lordships have taken recourse to these judgments. Now, the next judgment, and my Lord, my Ladyship, Justice Rother, your Lord asked me a question. Availability of land. The first part is, as per the OPWD code, no tender can be floated without the land having been acquired and without approval of the same. Now, that reasoning has also been proved to be wrong of the department. The Lordship may kindly say I filed an interim application that is at flag C. I'll come to that later. I'll explain that, Milords. Now, Milords, this is of this honorable court of 2017. Para 19, your Lordship may kindly come to. First, we'll go to Milords. I'll beg your Lordship's pardon. Para 2 first. The question involved.
The primary question involved in this petition is as to whether the tendering authority would be justified in cancelling the tender call notice without assigning any reason, even after the tender evaluation committee found two tenderers to be valid and the price bids were opened and recommendations made to the state government for acceptance of tender of the lowest bidder. This is my case. The other question to be considered is whether the reasons assigned in the counter affidavit for passing the cancellation order can now be looked into and considered or not. And if yes, then the reasons so assigned in the counter affidavit were justified or not. Now, your lordship may kindly come to para 19.
Yes.
Milords. In Messrs. Sri Ganesh Construction, I just gave the judgment to your lordship. Sri Ganesh Construction. This court has already held that cancellation of tender having been made by a cryptic order, the subsequent explanation given by way of filing counter affidavit is not permissible in law. As no reason was assigned in the impugned order, the same was...
See, this Mohinder Singh Gill has no application.
Milords, I can't say that. I can't afford to say that.
You can't afford to say, but yeah, this is the position.
I've gone through that judgment. I can't afford to say that.
Yes.
And Milords, para 20, in Messrs. DK Engineering and Construction, this court has taken into consideration the application of principles of judicial review to exercise of contractual powers of government bodies in order to prevent arbitrariness of favoritism. Right to refuse the lowest and any other tenderer is always available to the government, but the principles laid down under Article 14 of the Constitution of India have to be kept in view while refusing to accept the tender. In para 10 of the said judgment, this court held as follows. The freedom of government authority to enter into contract is not uncanalized or unrestricted. It is subjected to the golden rule under Article 14 of the Constitution of India. The government has to act impartially and in accordance with the terms and conditions of the tender. In accepting the tender, it is not always necessary to accept the highest offer. The choice of the person to whom the contract is granted has to be dictated by public interest and must not be unreasoned or unprincipled. The choice cannot be arbitrary or fanciful. Now, my lords, operating portion is para 21. In view of the above factual and legal analysis and taking into consideration the application of principles of judicial review to exercise of contractual powers, since the cancellation of tender has been made by a cryptic order, this court has jurisdiction to interfere with the same. Therefore, we are of the clear opinion that this petition deserves to be allowed. Accordingly, the writ petition stands allowed and the order dated 28/10/2016 passed by the opposite party number 2 chief engineer, whereby the tender notice dated 18/3/2016 has been cancelled, is quashed. Now, the next judgment, my lords, following all the three judgments, is also of the year 2017. Where the state government took a stand that the reasons were available on the website. But this honorable court has said that is not enough. Lordship may kindly come to para 11.
Yes.
Milords, again, your lordships. The lordships have referred to Mohinder Singh Gill.
Mohinder Singh, though, those decisions will have application.
So, para 12. Para 12.
Read it.
Reliance has been placed by the opposite parties, that is the state government, in Chandrasekhar Swine. In para 21 of the said judgment, it has been observed as follows. Annexure 7 dated so-and-so is the order impugned whereby the bid in respect of the work in question has been cancelled. The contentions raised by the learned senior counsel for the petitioner is that no reason has been assigned in support of such cancellation. To buttress his contention, he has placed reliance on Messrs. Sri Ganesh Construction, which I have just given to your lordships. On perusal of the materials available on record, it appears that on 28/11/2016, the Technical Evaluation Committee scrutinized the technical bids afresh on the basis of communication made on 17/11/2016. The proceedings of the Technical Evaluation Committee held on 28/11/2016, which indicate the reasons for cancellation of the tender in question, were evidently made available on the website. On the basis of such reasons, as a consequential follow-up action, the cancellation order was passed on 30/11/2016 in Annexure 7. This was not accepted by this honorable.
It was accepted. Please read.
Huh. In view of that, it cannot be said that the order of cancellation is a cryptic one. This is the stand of the state
Please,
government.
please.
When the same has been explained subsequently in the counter affidavit, if the reasons were available on to the parties on the website on the date of cancellation on 28/11/2016 itself, the communication by the Annexure 7, which was made on 30/11/2016, cannot be held to be unsustainable in the eye of law for not containing the reasons for cancellation of the bid in question. As such, Lordship may kindly mark that line. The ratio decided, Sri Ganesh, is absolutely not applicable. That was this stand of the state government.
In the said case,
In the said case, though reasons had not been assigned, but it was specifically mentioned that the proceedings of the Technical Evaluation Committee held on 28/11/2016, which indicates reasons for cancellation of the tender in question, was evidently made available on the website. Therefore, if reasons were made available on the website itself, the communication made without assigning any reason cannot be said to be illegal or arbitrary or unreasonable. Therefore, the case of Chandrasekhar Swai is distinguishable from the present context, and more so the law laid in Sri Ganesh construction.
so Chandrasekhar Swai was accepted to be good law because the reasons were mentioned in the website, but it said that it is different from the case of Sri Ganesh.
Sri Ganesh, where the principles of natural justice were not complied.
Accepted, yes.
Not complied with.
Yes.
Now, my lords, para 13. This is important as far as relates to the preceding para. The contention of the learned senior counsel for the petitioner to the aforesaid effect is fortified by the office order number so-and-so dated 20th March 2005 issued by the Central Vigilance Commission, which reads as follows. The Commission has observed that some of the notice inviting tenders have a clause that the tender applications could be rejected without assigning any reason. This clause is apparently incorporated in tender inquiries to safeguard the interests of the organizations in exceptional circumstances and to avoid any legal disputes in such cases. The Commission has discussed the issue, and it is emphasized that the above clause in the bid document does not mean that the tender accepting authority is free to take decision in an arbitrary manner, is bound to record clear logical reasons for any such action of rejection, recall of tenders on the file. So, whether it is available on the website or not, it has to be recorded on the file. 14. In view of the aforesaid facts and circumstances, this court is of the considered view that by way of subsequent explanation given in the counter affidavit, the communication dated 17/3/2017 in Annexure 5 and 6, cancelling the tender in question without assigning any reason, cannot sustain in the eye of law. More so in view of the Central Vigilance Commission guidelines dated 24th March 2005, the tendering authority is not free to take any decision in an arbitrary manner, and it is bound to record clear and logical reasons for any such action of rejection, recall of tenders on the file. In view of such position, in the absence of any reason communicated to the petitioner, the order so passed in Annexure 5 and 6 cannot sustain. Then they have taken recourse to the judgments earlier delivered and they quashed it. Now the next judgment, my lords. Lordship may kindly come to para 6. Para 6. Lordship got it? Para
Yes.
6.
Yes, please, please.
Having heard learned counsel for the parties and after going through the records, this court finds that admittedly opportunity of hearing was not given to the petitioner while cancelling the bid of the petitioner. Thereby, the order of cancellation so passed by the authority cannot be sustained in the eye of law. They have quoted Sri Ganesh, which I have just given to your lordships. They have quoted Messrs. Sickle Logistical Limited, which I have given to your lordships. And they have also quoted in para 9, your lordships may then kindly come to para 9.
Yes.
It relates to clause 10 of the terms and conditions of the contract, which gives an absolute right to the tendering authority to cancel the tender without assigning any reason. That has been deprecated by this honorable court as well as the CVC, that is the Central Vigilance Commission. The next, my lords, your lordship may kindly come to para 13, operative portion. In view of such position, no third-party interest can be created because of the fact that no leave was obtained from this court to award the work in favor of any third party pursuant to the second tender call notice issued by the authority. As such, the interim order is very clear that I don't have an interim order in my favor, my lords, as of now. So this is immaterial as far as I am concerned. But needless to say, the recommendations by the tendering authority to approve the tender submitted by the petitioner pursuant to first tender call notice should be accepted as expeditiously as possible, preferably within a period of 3 weeks from today. That is the operative portion. Now, next judgment, my lords, is of this year, 2024. Lordship may kindly come to para 7 and 8, where they have taken recourse to the earlier judgments, which have just served copies on your submitted copies to your lordships. Para 10, 11 also they have referred to those judgments. And Lordship may kindly come to para 11 sub-para. Para 11 sub-para. In view of the principle of law decided by the apex court, as well as this court, since the cancellation has been made without assigning any reason and without giving opportunity of hearing to the petitioner, the same cannot be sustained in the eye of law. In such view of the matter, since the order of cancellation has been passed by the tendering authority without giving opportunity of hearing to the petitioner, the second tender call notice issued under Annexure 1, so far it relates to work under item number 13, as well as the orders of the cancellation under Annexures 10 and 11, cannot sustain in the eye of law, and the same are liable to be quashed and are hereby quashed. Needless to say, the recommendations made by the tendering authority to approve the tender submitted by the petitioner pursuant to first tender call notice should be accepted as expeditiously as possible, preferably within a period of 3 weeks from today. And two such matters, my lords, were carried to the Honorable Supreme Court in appeal. The Honorable Supreme Court has confirmed the judgments of this Honorable Court.
There is difference between confirmation and dismissal of. There is difference between affirmation or confirmation of an order passed by the High Court and dismissal of SLP in limine.
Bow down. So this is my case, my lords.
All right.
I participated, I was declared as L1.
No, we are of the view. We, in fact, I am in respectful disagreement with the view which has been taken. That in the light of Mohinder Singh's Gill case,
no, that is not
and because of violation of principles of natural justice, the cancellation of tender notice was bad. So I may have to refer the question to a larger bench, and we will consider all the decisions which have been rendered.
If I may, Your Lordship. My Lordship, first of all, I want clause number 32 of tender call notice, which specifically says at page number 72 of my counter, which specifically says that authority reserves the right to reject any or all of the tender received without assigning any reasons. So this is in the tender call notice.
That is there in all tenders.
My lords.
But even then the court interferes when it finds out the case.
You have a very good opportunity to examine this aspect. He is relying on these decisions, division bench decisions of this court. There are two aspects. One, they are relying on Mohinder Singh's Gill's case.
Right, my lords.
How that decision is applicable in such matters, you have to examine that first. And secondly, he is contending that he was L1 bidder,
right, my lords.
and therefore he had a right to be heard before cancelling the NIT.
Right, my lord.
So these are two questions. In the division bench, it has been held that they ought to have been heard. And secondly, in view of Mohinder Singh's Gill's case, the contents of the order could not have been improved by filing an affidavit.
Right, my lords.
These are two questions. We are prima facie of the view that Mohinder Singh's Gill will not apply because that was a quasi-judicial order. And in that case, the court was of the view that the contents of the order cannot be improved by filing, by making
matter.
statements in the affidavit. And secondly, principles of natural justice will have no application in the matter of cancellation of NIT. So this is the prima facie view which we hold. That will depend on the decisions of Supreme Court. So many decisions are there. You will examine, and then you may address.
My lords,
So we shall formulate questions accordingly. And
yes, my lords. My lords, I can place 3 judgments of Honorable Supreme Court right now.
so you will fix a date. You prepare. You go through these judgments. Do you have a copy? Do you have copies of these
No, I have
judgments?
the citation list.
You have the citations. You examine.
Let my friend give me her citations also.
Citation.
Give her the list so that she must have copied down.
See, this is a question of law, plain question of law, and there are umpteen numbers of decisions on this point. So you are not required to have her citations. She may be even working on it on this point. She may be working on it. She should work and then address the court on those aspects.
Citation.
Orders clear. And
Either 22 or 2nd December. 2nd or
today,
today is 13th,
so Monday को orders clear.
18th को.
18th orders.
Sorry, Milas.
18th will place the matter for orders, and we may refer to these decisions.
And
We shall be formulating the questions of law to be referred to the larger bench.
My lords, meanwhile, if I may file a short synopsis in this. with the-
can you do it by
Tomorrow, by tomorrow you can do.
My lords, by
won't be able to
Monday morning I will be.
That is
keep it
18.
on Tuesday.
My lords, then tomorrow then. I'll do.
Tomorrow do it.
This will scan the.
Item 41.
Scan.
May I please? As the petitioner's praise of, that is the petitioner are the ST students and they are prosecuting their story.
What are you?
My lords, if I may, Suman Patnaik ma'am is conducting this matter. She is under some difficulty. This may be taken up after 2 weeks.
My lord,
41.
taken time.
2 weeks, no, she's saying that the counsel who is conducting the case are not available. 2 weeks may be difficult because the
Next week,
question
my
of
lords, next week.
Next week, Tuesday or Wednesday, my lord.
next Wednesday. Stipend of the
Stipend, my lord.
ST
The
students.
students already completed 1 year, my lord. Secondary is continuing.
As requested on behalf of the opposite parties, does this matter on 1 week?
Well, date make any please.
Date is always fixed.
Item 42.
Oh, my lord.
As you can see, last order, let's direct it because
Where is Mr. Palit? He's not there.
no. Whereas my case, leading case, let's. But they also can see last order because they have not filed counter in connect cases and they filed one counter in case of and senior counsel Mr. Palit appearing in all connect matter lordship. And they taken a decision lordship to adopt that counter in all cases. So that was
In fact, we have not filed any fresh counter, my lord. We need to adopt it, my lord. What we have filed in the other case, 28611 by.
No, but whether you have received instructions.
In fact, my lord,
I see the order dated 30/10/2024. If you
Yes, I
have,
have seen.
And without seeking instruction, don't take any stand.
But there is no instruction available in the.
Then you have it. Otherwise,
1 week more time may be granted to receive the instruction. Because
way of
I don't
last
find right
advice.
now in the brief.
1 week further time is allowed for an AGA to seek instruction in the light of this court's order dated 30/10/2024. 1 week.
43.
Lordship, in fact, in both the matters, Lordship, they stopped mining. I'm in operation.
1 week.
No, what I'm suggesting, Lordship, because they have stopped mining because I have not deposited the rest of the amount, which has been stayed by the Chanul court. Lordship, because the period is going away, Lordship. So if they are saying that I may deposit some amount, let me operate, Lordship. Otherwise,
So
the
we
time
will take up the matter after 1 week.
Lordship.
43.
In both the matters, Lordship, interim order there, Lordship, interim order to continue.
Continue.
Interim order is there.
Lordship, in conducted matter, interim order.
Last date, it has not been.
No, in both the first cases, Lordship, the interim order not there. First matters, in conducted matters, interim order there, Lordship. Because they have enhanced the additional charge, Lordship, after completion of the
Connected
agreement.
matter is item 43.
Both the matter, 42 and 43. Both the connected matters.
42. Tell me which is the matter.
42, Lordship, is mine.
2861.
Lordship. 28611, Lordship.
Interim order we had extended on P7 2024. It was supposed to be listed 31/7.
Yes.
Despite this interim order, they have stopped, Lordship.
There is a specific order on 3/7/2024 as regards counter. WPC 28611 of
Yes,
2023. Order dated 3/7/2023. On what count you have to file the
But
counter?
at the last
because
chance,
it's confined
last
to
chance,
prayer.
my lord, lordship, I am grateful that your lordship granted 1 week time, my lord. At the last chance, I will obtain instruction. I will come up before your lordship with specific instruction whether we have to file a fresh counter or we adopt it.
That is in 17936 of 2024.
Yes.
I'm talking about 28611 of 2023.
In all the matters, I will seek
Please
instruction.
check the previous
Yes,
orders.
yes, previous order. I'll check. I'll
No.
So interim order in 28611.
28611, Lordship.
Item 44.
In 43, Lordship, 18001. Lordship, in 43, connected matter, 18001. 23.
Here also counter affidavit not filed.
Not filed, Lordship.
So here was there an order whether they want to adopt or not?
Yes, Lordship, that is same. In both the cases, Lordship, that order.
Same order is there.
Lordship. That order on 17 and 79.
Yes. 3010 that order is there.
Lordship.
Always. Interim order is there in the second
Not
case.
sec-
There are separate order the second interim order will be extended. List will.
Yes.
44.
May I please your words. Like 44, there is an amendment application is pending, that is flag C. It's a 12155 of 2024, your lordships. It's filed on 10th September 2024.
For what?
For the pendency of I came to know the cancellation of my agreement. Agreement was cancelled, my person to order. So I want to brought that improvement. Flag C, your lordships. The writ petition was filed on my lord 27th August 2024. The impung order was passed, my lord, 29 August 2024. My lord. And that is.
We have already filed our counter.
Yesterday they have filed.
Yesterday we have filed copy shop. Now they want to bring on record certain facts and record which occurred after filing of the writ petition. After filing of writ petition, his my lord, tender has been, that agreement has been cancelled. Pursuant to your lordship's order given in other case, that we have followed that principle which the other petitioner raised, and we filed counter accordingly. Now, if they want to bring on record, we don't have, because this formal in nature, amendment may be allowed, but we may be given opportunity to file a separate supplementary counter affidavit to the extent the amendment is allowed.
Yes, your lordship.
Item number so and so has been filed. Seeking amendment to amendment in the writ petition in terms of the schedule of amendment. Of AGA appearing on behalf of the state does not have any objection to such amendment in the writ petition. Accordingly, IA number so and so is allowed. Let consolidated so and so be filed. That's this case. 2 weeks. 3 weeks. 3 weeks. So in the meanwhile, it shall be open for the opposite parties to file further affidavit. If further affidavit in response to further affidavit in the light of the petitioner's amendment having been allowed by the today's order.
And he may be directed to file consolidated petition.
That has been.
Already given. Your lordship already.
No,
already will sir. Oblige.
Much grateful, your lordship.